lords, because my lord, in the FIR I annexed in the bail application, some while making transaction, some my lord error has been committed. So I filed a fresh one, my lord.
Item number 20.
20, my lord. Right.
May I please, your lordship? Item number 52, lordship. Item number 52, lordship. I have taken consent from the other side. This matter may come after 2 weeks, lordship.
52.
52, I am for the petitioner. Applicant petition. On 27th, lordship.
You are for the petitioner.
For the applicant.
Considering and the request with the consent of the other side, and the council appearing for the applicant paid for an adjournment. You
On
want
27th, lordship. Deeply obliged.
May I please? Item number 48, lordship. Anticipatory bail.
yes.
In this matter, my colleague SAB Khobir will appear, lordship. Today he has some personal difficulty. Next week, my lord.
City receipt. You are Mr.
A.S. Ali.
Heard Mr. A.S. Ali appearing on behalf of Mr. S.A.B. Kabir for the petitioner, and also heard Mr. P. Portfolio and the petitioner P. appearing on the at the request made by the council for the petitioner, case is adjourned. However, CD is already received. The matter be, you are on, yeah, he was in interim, no? Are you on interim?
No, lordship. No.
When it can
From
be
16 to
CD will be retained.
next week.
60 CD may be 62 CD be retained.
May I please, Lordship? Lordship, I beg to mention item number 53 from Delhi Dispatch. This matter may be, this matter is wrongly fixed. As per order, it is 19-1, it is on 19-2.
Should be on 19-2. This, you are Mr.?
Ahmed.
Huh?
Ahmed.
No,
Item
you
53.
appearing for Ahmed or you are Ahmed? Yeah.
Ahmed.
You are Ahmed. Heard Mr. Ahmed, the London Council, the petitioner, and it is submitted. The case has been wrongly listed today, as it was fixed on 19-2-2020.
Entry may be,
Sorry, 26.
entry may be 22.
Considering this submission made by London Council petitioner, let the matter be listed on 19-2. Interim was there.
Right.
Interim be continued.
May I please, your lordship? I beg to mention item number 40 and 42, lordship. Out of same FIR, lordship, one matter fixed on tomorrow, lordship. Kindly take this matter
40 and
42.
Itu case number given.
6 AB 2977. Kindly take this matter along with AB number 2977. Fixed on tomorrow, lordship.
what is this? Tangoni.
And
Better
CD
not to
was
fix.
CD
Because tomorrow this bench we are sitting till 1 only. And from 2, the matter is fixed, one civil matter, part-heard matter that has to be taken up. So I don't know whether it may be reached or not. Already list is there.
Then, Lord, I have no problem if it takes today, Lord. The sir said that they will take it tomorrow.
No, if it reaches, then it may be hard. If it doesn't, then it won't be hard.
If they take, I have no problem.
I mean, if it reaches,
Yes.
or if your getting is there, then it's okay. Otherwise, we have a matter. From 2, we are not going to hear this matter. That's why. Only that is the reason. Otherwise, we can have, I can fix it.
Any other that I am on interim,
Will be,
lordship.
Because 4 years of this.
40 or
Otherwise,
50, considering hard
Yes.
hard MS. As past tomorrow's list, 2977 is not is before this bench, so it may be before the other bench. Okay, then corridor. So and so. Considering this submission made by an additional PP as well as the learned counsel for the petitioner, let this matter be listed along with AB 2977 2026 dated tomorrow. No? Tomorrow is 10th. Okay.
May I please, Your Lordship, I beg to mention item 35, my lord. As per order dated 16/10/2025, my lord, this matter was supposed to be listed before my lord, Honorable Justice Kolita, my lord, because another matter for co-accused was disposed of by that court.
Oh,
35.
Yes.
35 already started.
I know he is insisting that the matter should be for. If it is charge sheet is submitted, I don't know maybe the other bench may pass another order, but from this bench to definitely you may approach the learned trial court.
But the sessions type section is there. So my lord, interim is there, my lord. I have already appeared. If I appear.
So
for the
you
learned
want that
court,
it is to be fixed before Justice M. Kalita?
Yes.
The record.
Another co-accused, my lord, bail petition was
Disposed
of
by
by
him?
that. Yes. As per order dated 16/10/2020.
16?
10.
We are 35 with considering the submission made by Mr. Sigler, return account for the petitioner, and also in view of order passed on 16/10/2025, let the matter be listed before the appropriate bench. You were interim, I think.
Yes, ma'am.
Appropriate bench. In that case, next week or the day, we may come. Next week or 20. 20.
My, I know.
20 corridor. Interim be continued.
May I please, Your Lordship? Lordship, on Saturday, I had mentioned for listing Lordship for today, but the matter has been listed today, and subsequently that matter has been listed for tomorrow. If Lordship possible,
What kind of matter?
Lordship bail application, fresh bail application.
Bail application mentioning was not before this court, I think.
Yes, Lordship. In court
In-
number 23, I had mentioned 24, Lordship. On Saturday.
In that case, you make a mention of court number 8. Make a mention before court number 8. It may be listed.
But
It is listed tomorrow.
tomorrow, this
What is
court,
the
Lordship.
harm? It is listed tomorrow.
Lordship, there is an urgency, Lordship, because from 11, Lordship.
Probably it may not be possible today to list it today itself, because or rather you can approach the registry or court number 8.
Lordship.
Lordship, I am sorry, Lordship. I think I have wrongly mentioned item number 52 is 53, my lord.
Pardon?
I have wrongly mentioned item number 52.
50?
53, it's
Ah.
53, my.
It's 23.
53.
53 to hold.
53.
You have 53 only.
I'm sorry.
Lordship, I beg to mention a regular bail application, Your Lordship.
Make a mention before court number 8. Court number 8.
Your Lordship, I beg to make another mention for withdrawal, Your Lordship, for bail application.
Every mention has to be made before court number 8.
Obliged.
Made please, Your Lordship, I beg to mention an anticipatory bail. Anticipatory for like
Make
season has been, huh?
Make a mention before court number 8.
Court number 8. Always. My pleasure, Lordship. Lordship, I beg to mention item number 38. Although case diary is available, Lordship. Lordship, matter may be passable for the day, Lordship.
38.
38, Lordship. There is some difficulty, Lordship.
Are you on interim there? Interim was there?
Interim is there.
Heard Mr. D. Medi, then counsel for the petitioner, also heard Mr. E. Bortaku, then an additional PP, bring on behalf of State Dispute. Considering this submission made by Mr. Medi, the matter is adjourned today. However, CD is received. Let the matter be listed.
On 12/2, my lord.
You have to okay?
May I
Yeah.
please your lordship?
CD be retained till next date.
May I please your lordship?
Interim was he was in interim.
Yes, interim is
be
in.
continued till next.
I beg to mention item number 36 and 37. Lordship, kindly matter may be passed over for the day.
What is the position of 36 and 37?
36, my lord, search sheet submitted.
Lordship, any direction may be given.
And 37? So, otherwise you are appearing in behalf of the, because 36 already CS submitted.
Kindly direction may be given to the
we are
lower
giving-
court below.
And
Yes.
37 we have not received the
Not,
case diary.
yes, CD
Are
notice.
you on interim there?
No, Lordship.
Interim was not there. You are MS?
R. Shaheen.
R?
Shaheen.
Shaheen. Hard MS R Shaheen. 36 to take off. Hard MS R Shaheen, the learned counsel for the petition, and also hard Mr. P. Bottom, the learned additional PP appearing on. Case was fixed for case diary, but it is submitted by Mr. Bottom. That case has already been charged sheeted. By CS number
My lord, CS number 304/25, dated 31/5/25.
Select. Was there any interim order?
No,
Are
my
you
lord.
on enjoying interim? As the case has already been charged sheeted, the petitioner is hereby directed to appeal before the learned trial court below with an appropriate application for bail, which may be considered in accordance with. You have received any WT or
Yes, WT message received.
WT message be kept with the case record. With the above direction, the present petition stands disposed. So you immediately make the application before the learned trial court below. And in regards to AB, 37, we get to look up hard MS R Shaheen, the learned counsel for the petition. Also hard Mr. P. Water pursuance. CD not received, it's a reminder. It has to come from which district?
Gauhati, my lord.
So how many weeks?
On 17 or 18 to
17 or 18.
17.
Can it be on last week of February? Any
Interim
day?
was interim.
Interim.
Last
In case counsel application
In that case, we are listing it on 27.
Yes.
of next.
May it please your lordship.
Yes.
My lord, may I kindly come to the FIR. What had happened, my lord, there was a mob violence altercation between two groups. And as a result, my lord, a person, he received certain injuries and subsequently succumbed to those injuries, my lord. Page number 9. Now, my lord, the present
Page number 9.
9 is the FIR.
Yes.
Now, my lord, the present petitioners are appearing in their higher secondary examination day after tomorrow. And their name is also not there in the FIR, my lord. They were bystanders. And their name and all the young people of that locality, they have been arrested, my lord. My lord, we'll see one of the co-accused, the forwarding report. There were about 8-9 such students were appearing in higher secondary examination day after tomorrow. One of those co-accused has applied that regular bail application, my lord, arrested on the same day, same forwarding report. If your lordship turns to page 16, this is the same forwarding report. One of the co-accused appeared, and considering the age and the career of the young boy, my lord, an interim protection was given so that he can appear in his higher secondary examination. I have also annexed the admit cards of the petitioner along with this petition. Lord, if anything, your lordship will see the same forwarding report at page number 16. The order which I am relying on, the name of that accused, your lordship will find at accused number 2, Ankur Jyoti Sharma. And that's the order of Ankur Jyoti Sharma. And my clients are accused number 3, 4, 5. They are all higher secondary students. This group of young boys, my lord, they had no participation, nothing, my lord, random arrest. And their admit card, your lordship will find at page number 21 is the admit card of the petitioner number 1 is at page 21. Examination starting from 11th of February 2026. Final examination. And for petitioner number 2, the admit card is at page number 23. And for petitioner number 3, the admit card is at page 25. These are all higher secondary students, my lord. Their career is at a stake. If because otherwise also this court has called for the case diary on 26th, my lord. If at all, if something comes out, your lordship is at liberty to cancel. But my lord, we are certain, my lord, nothing will come out, my lord. But be that as it may, my lord, your lordship may peruse the case diary, but at least, my lord, they should be allowed as an interim to participate in their examination as one of the co-accused has been allowed to appear in his higher secondary examination.
Two person died here.
No, one person. No,
No, as per the FIR,
no, my lord.
তেখেতে যোৰহাট মেডিকেল কলেজৰ শেষ নিশ্বাস ত্যাগ কৰে আৰু শুনিব পোৱা মতে কোনোবা আৰু এজনে মৃত্যু খাব দুজন
No, my lord. My lord, we'll see the FIR which is at page number 9.
original FIR is at 15. 2%.
Yes, Mala initially attacked one Durga Prasad Jaiswal, who was an advocate, and thereafter.
No, Durga Prasad Jaiswal has nothing happened to him.
And your lordship may kindly come to page 20, my lord. Here, incident occurred on 31/12/2025. And my lord, exam is going to be held on 11th of February, my lord. Ground number 5. During investigation, it also revealed that all the accused person consumed alcohol and was in aggression and caused brutal attack to civilians as well as other. And after the attack, all the accused persons fled away from the scene. And because of that attack, one person, my lord, expired.
One person expired, my lord. These are in relation
This
to some.
incident occurred on 31/12, and my lord, exam is going to be held on 11th of February.
My lord, these are all what police have written, my lord. These are yet to be proved, my lord. But the matter remains, my lord. They are higher secondary students. They are appearing day after tomorrow. They have not participated in this, my lord. Their parents are, and my lord, one of the co-accused was already given permission by this honorable court, my lord. What I am submitting, my lord, on 26th, if something very strange comes out in the FIR, very unlikely, in that event, your lordship is always at liberty. But at least, my lord, if nothing comes out, their career should be saved, my lord. He's a local boy, my lord.
Your examination ends on when? 26th?
Yes. Timetable to this.
No, 11th of February, my lord.
It starts on 11th of February.
Yes, 11th and then?
Today is 9th, my lord, day after tomorrow.
Hard Mr. M. responsible and also for the petitioners and also hard Mr. P. Waterford and petitioner PPA. Then applications, students, connected with students. Is submitted by Mr. Biswas that the present three petitioners are innocent and they have not involved in the arrest. They are not involved in the arrest. After the incident, some young boys, basically the age of young boys have been intercepted, arrested by police in connection with the offense, only on suspicion. Further, he submitted that all the three petitioners are in custody since when they got arrested.
1/1/2026. 39 days, 40 days almost.
1/1.
Yes, 1/1.
1/1/2026, and since then they are in custody. However, all the three petitioners are going to appear their final higher secondary examination, which is going to commence from 11th of February 2026. The admit card of all the petitioners are also annexed along with the present petition. If further submitted that if the present petitioners may be allowed to go on board, or they may be allowed to go on interim bail so that they can appear their exam. All the three petitioners are ready. All the three petitioners will provide necessary bail, and there is no chance of absconding. They are granted bail. Next part. Mr. Waterford and additional PP submitted in this that the one person was very brutally killed by a group of persons, and the incident happened only on 31/12/2025, and hence the case is still under investigation. Accordingly, he submitted that releasing of bail at stage may also hamper the investigation so far. Investigation of the case. Next, we are considering this submission made by learned counsel for both sides. Without going detail into the merit of the case, only considering the fact that all the three petitioners are going to appear their final exam as secondary final examination, which is going to be commenced from 11th February. And also considering their young age, the petitioners, namely Swens, are hereby allowed to go on interim bail on furnishing a bail bond of ₹50,000 each to the satisfaction of where cases.
It is Golaghat. That
CJM.
would be Chief Judicial Magistrate Golaghat.
CGM Swens. In the meantime, CDB called for and interim bail allowed to go on interim bail till
On 26th to one.
other one is
26th.
26th of February, calling the case diary. In the meantime, CDB called for.
The same item number 4 is also same with respect to other candidate, one other candidate. Item number 4 same, only it will be petitioner, this is petitioner, and the name will be different, otherwise everything identical, admit card. The other items 4 to the person.
অঙ্কুর শর্মা
তিনিটা অঙ্কুর আছে।
Ankur Sharma, he is.
There are three
he is
Ankur,
not
Ankur
the
Jyoti.
appearing exam, I think.
No, there are 3 Ankurs.
Huh?
One is Ankur Sharma, one is Ankur Jyoti. That from the forwarding report, your lordship may see, this present petitioner is accused. One is Ankur Jyoti Sharma, the other is Ankur Bosumotari, and one is Ankur Sharma. This is accused number 10. This item number 4, and the admit card your lordship will find at page number 21.
Number 1 is also Ankur.
Ankur. There are a lot of Ankurs, madam. It seems to be a very popular name in that locality. One is Ankur Jyoti Sharma, one is Ankur Sharma, one is Ankur Bosumotari.
Ankur Jyoti Sharma, son of Piku Sharma.
And this is accused number 10. From the forwarding report, if your lordship sees, this particular item number 4 is with respect to accused number 10. Ankur Sharma.
I go to accused number 3. Yeah, A2. Okay.
Same order. Sure.
Same. I'm deeply obliged, my lord. Can wait.
May it please your lordship. My lord, FIR is at page 19. 19. 105, my lord, culpable homicide not amounting to murder. Date of FIR, your lordship will find right-hand side top, 1/12/25. Date of incident, 7/6/25. After 6 months, FIR was filed. One line is there, গতিউক্ত ঘটনার উপর প্রতীক তদন্ত করি দক্ষিক কায়স্থ করি উপস্থিত সদস্য prior to that, যদিও জুয়া ইমান তারিখে প্রায় রাতি মানব ডক্টর লোল there is one statement চিকিৎসা আৰু মৃত্যু হত্যাৰ কামত ব্যস্ত থকাৰ বাবে এজাহাৰ দিয়াত পলম হল bottom there is one line is there but after 6 months I was arrested on 29/12/25. I am number 4 in the list of accused. Mujibur Ali.
He died subsequently.
Malad?
Yes.
He died.
Subsequently,
After death, my lord, the FIR was closed.
105.
Yes, what
Yes, my lord, although my lord FIR after 6 months FIR was lost, that is after the death of the my lord victim, my lord, this FIR has been lost, my lord. In one preliminary inquiry report is also at page 20. My lord, after that preliminary report, my lord, not only the FIR, my lord, preliminary inquiry was also done. Thereafter, my lord, on 30/12, present petitioner was arrested.
let this city be called for it.
Yes, yes.
Only a short date with Kamruk Metro.
Actually, we don't have any right. How many cases have been already been fixed? You are quite competent. Come. 16-2.
Right.
City be called.
FIR is page number 9, Lordship.
Just give me FIR page number 9.
Page number 9, Lordship. Case is related to the sale of some fake gold to the informant, Lordship. My name is not FIR. I am not named FIR, Lordship, in this case, Lordship. And behind the bar, 55 days. 60 days is a mandatory period, Lordship. Today is 55 days. And Lordship, kindly peruse the forwarding report. There is nothing mentioned against me. I am no way connected with this case, Lordship. Even I don't know the accused person. FIR named accused person, sir. Forwarding page 20 is a translated copy, Lordship. Vernacular copy at page 24, Lordship. Nothing has been mentioned in the forwarding as well as the FIR regarding the present petitioner, Lordship. He is nowhere connected with this case. And today 55 days is custody, Lordship. 60 days is the mandatory period. Even, Lordship, under notice under section 35(3) also not issued to the petitioner. Maximum punishment is the 7 years in all this section, which is incorporated in the FIR, Lordship.
It's a case of fake gold.
Fake gold, Lordship, accused person, I am not FIR named accused. Lordship, I am no way connected with this case, Lordship. Even kindly peruse the forwarding report, Lordship. Nothing has been mentioned against me, Lordship.
Trial court rejection order is at page 26, my lords. Third paragraph, last portion, my lord, page 26. Further, on the basis of statements of witnesses and other materials collected, it reveals that the arrested accused persons are actively and directly involved in the organized security.
There is a many arrested persons, Lordship. This is a common order. Nothing has been mentioned in the forwarding against me, Lordship. But today is the 55 days. Behind the bar, Lordship, 60 days is mandatory period. Even, Lordship, notice under section 35 we also not issued to me, Lord.
Otherwise, my trial court rejection order reflects that he is actively involved in the organized security.
This is a common
Regarding
order.
my-
Other accused also they are.
Regarding length of detention, my lord, after some time I will try to get the instruction whether search sheet, if search sheet submitted or not.
I mean, we're
Mm.
keeping it and
Regular bail application under section 483, allegation under section 305 and 331 within bracket 4. Your Honor, the petitioner has been arrested on 23rd January 25. The petitioner is basically the petitioner is the helper of the driver of crane and forklift JCB. They were working in under highway construction. During the daytime, they have bought the diesel and they used to in their forklift and JCB. And when they stop their work at the night time and the remaining diesel they are carrying in that said vehicle to their uh, uh, camp, and during that time the police has snatched the diesel and alleged them against that they have stolen the diesel, but actually the diesel has bought in daytime by them for using their JCB and crane. They have not stolen it, my lord. And
drum,
they have
any quantity has been mentioned here, no?
no, it was they have no idea
Only
about it because
grams.
they have
Your lordship may kindly peruse page 19, my lord. Page 19, top, my lord. It was revealed that Sodhi Singh, Omit Rajbor, and Sofikul Islam is the present accused, my lord,
yes, ma'am.
had stolen the diesel from the cranes and forklift being used at the under construction Jorhat flyover for the purpose of illegal sale to Susanto. Based on the written complaint, an inquiry has been initiated. So,
Susanto is the driver of that FP vehicle, which they have by which they have carried the diesel, remaining diesel to their use only. They bought it in the daytime for their use only, my lord.
That is your submission. We are
They
is
are
submitting from
they are the
Gauhati.
driver of the Poklan and JCB. Yes, ma'am. And the my petitioner Sofikul Islam is the helper of them.
But the allegation that you along with two others had stolen the
Allegation
diesel
is that-
from that
Yes.
flyover and also only with a view to sell it to that Susanto, which is your driver.
Yes,
That
and
is the
more,
allegation.
yes,
and
ma'am.
not
Moreover, the section 331 is not applicable here, my lord. It is not house trespass, my lord.
305 is there.
305 is also there. Anyway, where from it has to come? Your pay,
My lord,
Jorhat.
from Jorhat, my lord.
your hat.
Arrested only on
23rd.
23/1, my lord.
It is 18
Not
days,
even
my
one.
lord.
15 days. On 18.
18. 18 to.
Obliged, my lord.
Lordship 483, Lordship. Lordship, as are in page number 9. Lordship, allegations are Lordship 331, subsection 4, Lordship, trespass, Lordship, and theft, Lordship. So, CG may be called for.
At this stage, we are going call for state seat.
Yes, yes. The sorted, I pay for sorted, Lordship. The Patasar Kusi, Lordship.
16 to.
Published.
It's a 483 application, my lord. 18 days in jail, my lord. In connection with my lord for shown arrest, my lord. Arrested on
You were shown arrest?
Yes.
Yes.
In for which connection?
Tata Sargasi police station case number 3, my lord.
Under which section?
Under
305.
yes,
305
331.
the cow theft, my lord.
It's a theft of cow.
Yes.
Okay, this is the CDB
Page 15 is the, my lord, prayer for shown arrest.
Yes, my lord.
15.
Yes,
Yes,
page
15.
You may be involved in other case also, na?
Yes, my lord.
Already in jail, my lord. Today, my lord, they are carrying in another cases, my lord.
In here, in connection with this case, he is in 18 days in jail.
Yes, my lord.
Yes.
And
Otherwise, he
other
was
case,
in
my lord, on 5-1, my lord, from 5-1.
from 5-1. And the incident, your incident had happened on which day?
Yes, my lord. That incident happened on, my lord, that is on 8. It is
On 26/12.
26. 26/12.
Oh, that is on 26/12. Okay, most probably, considering your earlier antecedent, you got arrested, maybe. CDP called for.
Tomorrow, there's similar matter, my lord.
Similar matter is
Yes, my
fixed.
lord.
CD is already fixed.
Yes.
Number 2.
Number, my matter may be on 11 or 12. Tomorrow, I will not available, my lord.
Then in your case,
Yes, my lord. That why, my lord. Tomorrow, my lord, similar matter is pending, my lord.
16-2.
Six.
1-6.
1-6. Obliged.
Lordship, 483 applications.
10303.
FIR is in page number 16, Lordship. Allegation is 103. Your Lordship, the victim, deceased victim, went missing on 17/11/2025, and his body was recovered on 21/11/2025.
And your petitioner got arrested when?
I was arrested on 21/11, Lordship. Lordship, the deceased victim was working under me as a laborer. I'm a sardar, Lordship, who provide laborers to the brick factories.
So you are not aware about his missing?
I was aware. I accompanied the parents of the missing person, victim, and filed a missing report in Nelly police outpost. And after that, I visited the outpost numerous times to know the whereabouts of the victim. But after that, Lordship, on 21, they made a phone call from the police station that a body was recovered, and I was called upon in the police station to identify the person. The FIR was filed by the uncle.
You are Ikramul.
Yes, Lordship. And his parents were also working under me as laborers in the brick factory, Lordship.
But on the day of incident, as per the FIR, you called him to your quarter.
Yes.
In your quarter.
No, Lordship. Once a week I visit the brick factory to pay the weekly wages. And on that day, on 17/11, I went there to pay the weekly wages. Then I left with my uncle. After that, he went missing.
103.
Yes.
So now, till now, you are in custody since 60 days or what?
81 days, Lordship.
81 days already over.
From Morigaon, my lord.
Lordship, kindly give
From
a thought.
Morigaon.
On my lord, 13/2.
13/2 will be 2 days, 10 night.
9. 13/2 Friday, my lord. Next Friday. Next.
This Friday only.
Next.
CDB.
Highly obliged.
May I please, Lordship, on the day of occurrence, the accused petitioner was forcefully entered the house of the victim, Lady, Your Honor, and forcefully committed rape, Lordship. This is the allegation. The medical report says nothing has been revealed, Your Honor. Subsequently, case has been charge sheeted, though FSL report is yet to submit, Your Honor. I have challenged the filed a petition for bail in the learned session court, which has been rejected. Your Honor may peruse the order dated 28-1, page 38. Your Honor may peruse page 39 of operative paragraph.
Yes.
Record reveals that fight order dated so-and-so passed in BA number so-and-so. The earlier bail petition of the above named accused was rejected on the ground of the seriousness and gravity of the offense. BA number 1113 of 25. Earlier occasion also for the same PS case number, we had filed a petition, but that petition was rejected on the ground of seriousness and gravity of the offense. But another case was pending of the petitioner by Hatigao case, Your Honor. Similar nature of offense, Your Honor. After filing of charge sheet, that case has been allowed to grant, allowed to go on.
Similar nature. That means you are what kind of person?
Yes.
Lordship.
In earlier also,
Yes, Lordship.
here also same.
Lordship. I was a ward member of a Gau Panchayat for the year 2008 to 2012, Your Honor. Subsequently, I was president of the Gau Panchayat for the year 2013 to 17.
Achha.
But in this year, on Nur Farida Khatun, who was elected for ward member, I have challenged the said ward member before the learned election tribunal Borbeta, Your Honor. After filing that election petition, I was threatening and subsequently in Borbeta district, being Kolgasia PS and Kasumara PS, to which occasion I was detained, Your Honor. But no case was made out. Subsequently, I was released by the police, Your Honor. But in the Gitanagar police station and Hatigao police station, two false case has been filed by some unknown person. I could not recognize that lady who has filed the FIR, Your Honor.
What is the stage of the case at present?
At yet to commit.
Charge it, huh?
Charged, but yet to commit the case.
Yet to commit.
Yes.
Not yet committed.
Not yet.
Well, here in the rejection order, there are mention of two cases, present case and one another Hatigao case. During his submission, he submitted regarding one another case. Regarding them, so he is involved in similar in many other cases, maybe. This is my third case against him. Already submitted, scan copy maybe.
Today is 83 days, Your Honor. Those are set up.
Now 83 will.
Yes, but my humble submission would be, since FSL report is yet to submit, Your Honor, charge sheet is not complete charge sheet, Your Honor. That submission would be my in hearing, Your Honor.
Mr. Rahman, na?
Rahman.
Heard Mr. S.H. Rahman, the learned also heard Mr. P. Bot, the learned petitioner, it is submitted by Mr. Rahman that this present accused petitioner is innocent and only for the political rivalry, the present case has been lodged against him. He further submitted that in connection with the present case, the case has already been charged sheeted, but the FSL report is yet to be furnished and thus it is not complete charge sheet. Next, Mr. Waterford, the learned additional PP submitted in the scan copy of the PCR along with the case diary may be called for to know the actual fact of the case. Let the scan copy of the PCR along with the case diary be called for from the learned track board below, retrievable to the need list accordingly. It has to come from Kamrup Metro, na?
Kamrup Metro.
17-2.
Okay.
Maybe Lordship. Lordship, offense relating to Lordship, dowry death, Lordship. Should you call for Lordship? Forget to do that.
আমি এটা আপনাদের করে দিন বাকি আর। তো এটা কি? It's a dowry date.
Yes, Lordship. She's the mother-in-law, Lordship, and as on today, 29 days behind the bar. CD may be called.
This is for your mother-in-law.
Mother-in-law, yes. Short date may be given, Lordship.
10 নম্বর 10 নম্বর CTB call. It has to come from which place?
Bijni, Lordship, I got it.
Bijni.
Bijni, AC ranks, yes.
We have to explain it. 18 to at least.
Lordship, some earlier may be given, Lordship. Some earlier.
Sorry, 18 to.
All right.
May I please, Lordship, my lord, I was arrested on 8/1/2026, my lord, 30 days, 32 days in custody, my lord, and allegation, my lord, is that, my lord, some Arctic goods, my lord, were stolen from a godown, my lord, and I was arrested only on the basis of two accused statement, my lord. 32 days in custody, and my lord, 60 days is a mandatory period, and my lord, no notice under section 35(3), my lord, of BNSS was issued, my lord, and it is mandatory now, my lord, to comply with the Anuj Kumar judgment, my lord, that has not been served. If possible, my lord, I may be allowed, my lord, 32 days in custody, my lord.
Yes, but
This stage CD may be called for, my lord. Any short date may be fixed. Your lordship may grounds of arrest is at page 17, my lord.
On the basis of the statement of some other co-accused, my lord, I was arrested, my lord. That is page 17, para 3. But nothing was recovered from my possession, my lord.
And why, my lord, section 35(3), my lord, notice not issued? The reason is also mentioned there in ground number 9, my lord.
That cannot be, my lord, because I have to give given an opportunity, my lord, whether I will cooperate or not. Because I am a permanent resident of Assam, my lord.
okay, let us see. He is in custody since 30 days.
32 days, my lord.
32 days, we called for the case diaries, giving the.
Yes.
This has to come from which place?
Bosishto, my lord. What?
This come from Metro. 17 to.
My lord. I love that.
May I please, Lordship?
Yes.
My lord, application under section 483, my lord. FIR at page 10, my lord.
Yes.
Can my lord? May I read, my lord? In this case, my lord, when the offense was occurred, incident was occurred at the time the petitioner is in Gauhati sitting in an examination, pre-final examination of ASS, my lord, and the offense occurred in Baksha district, Tamulpur. And in that situation, after completion of examination, the petitioner was called by the police and he appeared before the Mushalpur police station, and on his appearance, he was arrested. This is the offense, and my lord, the offense is, allegation is serious, that case is registered under section 108, 351 plus 3, 69 and 308. My lord, on 11th of February, my lord, examination is going on. He is about 19 years old, tender as a boy. And at this stage, my lord, any condition, if it is re-arrested, then also just the petitioner should allow to appear before the examination.
So offense is very
It
serious
is,
in nature.
my lord,
Cannot be, otherwise we can direct
yes,
the jail authority to help you in appearing before the
Yes,
yes,
examination center.
yes, ma'am.
That
But
might be otherwise.
jail authority in Nalbari and exam center is Guwahati. ma'am.
Then they will make communication with the jail from the other place. We don't have any,
And,
because entire allegation against you is a very
Yes,
serious allegation.
that is there, my lord. But the certificate is at page 18, my lord, one certificate issued by the principal of the institute that when the offense was incident was happened, he was in exam hall,
Who was in exam?
my lord.
Who was in exam hall?
The
Your
police-
petitioner.
Yes, my lord.
Ah.
That
No,
is,
this
my
is the
lord.
case of she committed suicide.
Yes, my lord. Abatement of suicide, my lord, it is any condition, my lord. If it is required, then he may be taken custody subsequently also. But at this stage, it is tender as his career is collapsed, my lord.
Very serious. Yes, what a
otherwise, my lord, from the grounds of error, it reflects that dying declaration may not be admissible at the my lord, later on, but that is a different aspect. But at this point of time, one dying declaration is also there, my lord.
where in this stated? In
Yes.
para?
Paragraph,
Dying
my lord.
declaration.
Paragraph?
Paragraph, my lord.
No, no, in page number?
Page 15.
Page
There are
15.
three.
Page
Bottom.
15. Ground number 3, my lord. Ground number 3 and 4. And
It is termed as dying declaration when the victim was returned from one of his friend. On the way, he stated something that this is going on with her.
regarding admissibility of that dying declaration will come later on, my lord. But at this stage, my lord.
No,
Either way, my lord, I am
the
not
oral dying declaration may, if the person before whom it was made, if can be believed, then it may be a piece of evidence also. At
Yes,
this stage, we cannot say.
Yes, yes. At this stage,
Heard Mr. Q. Amit, the learned counsel for the petition, also heard Mr. P. Bottom, the learned additional people on behalf of state respondent. It's an application, section so and so, in connection with so and so. It is submitted by Mr. Ahmed that the present petitioner is innocent. He is not connected with the alleged offense. Some false and concocted allegation has been brought against him. He is in custody since when? 81.
Since 21.
21.
21. It is today 19 days.
21/1/2026. He is in custody, and he being a student of higher secondary, his final examination is going to commence from 11th of February. You have annexed here admit card and
Yes, my lord. Page 20, my lord.
page
20. And the exam program is 21.
11th February, so and so. Accordingly submitted that the petitioner may be released on bail at this time. Next one, Mr. Watkins, and people submitted in the cases of very serious in nature, very serious in nature, and from the arrest, the memo of arrest, from the and from the forwarding report, it reveals that the deceased girl, also gave her dying declaration. As per P-Part submitted, and as per the admissibility, as per the admissibility of the dying declaration may be looked into at the time of hearing of this case. But from a side, it is seen that there is also dying declaration. The deceased girl, and accordingly, Mr. Bottom submitted that CD may be called for to know the case. Next, considering the submission made by learning counsel for both sides, and both sides, I find it necessary to call for the case diary. However, considering the submission made by Mr. Ahmed and also considering the fact that the accused petitioner is going to appear in his final examination, the jail authority is hereby directed to make all necessary arrangements for the present accused petitioner appear before the examination hall, and so that he can appear before the examination hall and can give the examination. Let CDB call for fixing on March 26th of February. So let the copy of the order be sent to the superintendent of which jail? He is in
District Nalbari, my lord.
District Jail Nalbari to do the necessary arrangements.
Obliged.
May I please, your lordship? My lord, your lordship may kindly see the FIR, my lord, vernacular page 13, my lord. May I read, my lord?
Please?
13, my lord, vernacular one, my lord. May I read, my lord?
Yes.
My lord. সন্মানপূৰ্বক নিবেদন এই যে মোৰ ভাইটিৰ ল'ৰা মানৱ মহন্ত নিজ ঘৰত ডিংগিত চিপ জৰি লোৱা অৱস্থাত উদ্ধাৰ কাৰণ যোৱাকালি সন্ধিয়া আশিক আহমেদ লগত 4-5জন ল'ৰা মানৱ মহন্তক বেয়াকে মাৰধৰ কৰে আৰু পিছত দীপাঞ্জলি মেধিও চেণ্ডেলেৰে কোবায় দীপাঞ্জলি Medhi is the petitioner before your lordship, my lord. My lord, what happened, my lord? That boy, my lord, who committed suicide, my lord, in his house, my lord. He, my lord, proposed the petitioner 2-3 times, my lord, but she rejected, my lord. And on that day, my lord, that boy again come, my lord. He proposed her, my lord, when she rejected, my lord. That boy, my lord, used some abusive word to the petitioner, my lord. On, my lord, anger, my lord, she gave a slap to the boy, my lord. And subsequently, the nearby people that mentioned in the FIR, Ashik Ahmed and 4 other persons, they, my lord, nearby people, my lord, they came and, my lord, assaulted the boy, my lord. And subsequently, on that day night, my lord, that boy committed suicide, my lord. And that Ashik Ahmed, my lord, who has assaulted the victim, deceased, my lord, he has been granted, my lord, interim bail, my lord. Page 15, I have annexed the order, my lord. And that case is fixed on, my lord, 1924 case diary, my lord. Interim was granted, my lord. So both the matter may be taken, my lord, and interim may be granted, my lord. That Ashik Ahmed has been granted bail, my lord, interim bail. Page 15.
Let the CDB there, lordship, because the issue is regarding this petitioner, lordship. As the learned friend has submitted, lordship, there was a proposal from him. So let the CDB there. There might be anything more, suicide note or something maybe there.
My lord,
Let us see the CDB because 19 is fixed for the CDB, lordship.
my lord, your lordship may kindly see the FIR specific, my lord, that Ashik Ahmed and 4 other persons, they assaulted the boy, my lord. The petitioner, my lord, although it is mentioned, my lord, that she assaulted with the sandal, my lord, but that is not true, my lord. The accusation is there, my lord. The Ashik Ahmed and 4 other persons, there is specific in the FIR, my lord. They have assaulted, and subsequently, my lord, the Dipanjali Medhi also slapped, my lord, her with that boy with the, my lord, sandal, my lord.
There are difference.
My lord.
Assaulting by some other person
My lord.
because there was an incident, so some boy may come and assault him.
My lord.
That is more
My
or less a normal
lord.
condition.
My lord.
But the girl
My
for whom he had the love affair.
Not love
He
affair, my
went-
lord. One side, my lord.
No, he had.
He proposed,
I'm-
my lord.
Yeah, yes,
Yes,
he
my lord.
proposed. He
My-
had.
My lord.
He loved her.
My
He
lord.
proposed her.
My lord.
And from her side, when this incident had happened,
My lord.
it may cause something. I don't know. It may be a case of 306. I mean, earlier 306
My
or
lord.
308.
My lord.
Or may not be also.
My lord.
Because that's same. But let the CDB call for it is fixed on 19.
19.
Let it be on 19.
My lord, interim, my lord, because the other FIR name accused are on interim, my lord. And he's a lady, my lord, 24 years of age, my lord. If she arrested, my
for
lord.
her only the incident
My
had
lord, if she
happened, not
arrested,
for the other boys.
my lord.
Incident had happened not for the other boys, but for her only.
My lord,
He committed suicide for her only, not for the other
my lord,
boys.
because that boy, my lord, every day, my lord, he disturbed that
I
girl,
can
my
understand
lord.
there
That
may
also
a
be
case.
considered,
I
my
can
lord.
understand that.
He,
Well, considering we may consider it, it will fix it on 19 too.
I'll kindly protect, my lord, the lady, my lord, before your lord.
CDB call for.
But that fixed along with that matter, my lord.
19.
Yes, yes, hi, along with that. Other one, yes, other number is
AB 168, my lord.
AB
168, my lord.
168
of 26, my lord.
19.2 along with CDB call for fix on 19.2 along with AB 168 of
26. Obliged, my lord.
Did to. Okay, go. Okay, fine.
Below left over.
13 over 14.
13, 14. 13 non.
Please, your
Yes,
lordship.
Mr. Mehdi, yes.
Lordship, 482 bail application, Lordship. Lordship may call for any report whether any case is pending against the present petitioner, Lordship, from Nunmati.
From Nunmati.
Nunmati.
Heard Mr. D. Mehdi, the learned counsel petitioner, and also heard Ms. A. Begum, the learned petition PP, appearing on behalf of state respondent. Considering this submission made by learned counsel for the petitioner, let report be called for from Nunmati police station as to whether any case has been registered against the present petitioner in the said police station or not. The learned additional PP will also take necessary steps in obtaining the report from the concerned police station. When it can be fixed as per him?
Lordship, after 1 week, Lordship.
And
19, Lordship.
Lordship, item number 15 is also a similar matter, Lordship, from Dispur police station.
oh, okay, it is also from similar. This is also that is also from the same petitioner.
Yes.
Same order, 19. But the matter, this is from, one is from Nunmati and other one is from
Dispur.
Dispur.
Deeply obliged.
May please, Your Lord. 16 and 17 lordship arising out of same FIR.
16 and 17.
Lordship. Lordship will have the FIR page 12.
Page 12.
Lodge. The translated copy, Lordship.
Yes.
Lodge. With respect, I beg to state that at night, in the night of 24/1/26 at about 8 p.m., my only son Anjan Das, along with his friend, went to see the Maghi at Chubankata, and while my son did not return home, I was passing the vigil night. In the meantime, around 2 a.m., I heard halla outside the door of my house. I went out and saw a young man pushing the motorcycle number 7 towards my house. When I asked the young man what was that fight about, then he answered that someone was trying to brutally kill a person. I asked again who was fighting. Then the young man said that it was Ravi. At that moment, I turned on my torchlight and saw my son Anjan Das being confronted on his way back near my village under the leadership of Vibhuti Pathak, along with Ravindra Das and 2 other persons were attempting to kill him. At that moment, I screamed to save my only son. My only son Anjan Das made every possible effort to save his life. Even then, Vibhuti Pathak attacked again and threatened to kill him. I moved forward and saw my son was lying unconscious in blood in a critical condition. Vibhuti Pathak, Ravindra Das, along with 2 other persons who attempted to murder my son, fled the scene. Immediately, with the help of local people, I took him to the local hospital called Robi Boro Civil Hospital. It is worth mentioning that the local hospital informed us that since his condition is extremely grave and critical, my son must be referred to GFCH. Today, as per the doctor's advice, we were taking him there. Therefore, I humbly request users to take appropriate action. Lordship, this is the affair. Basically, Lordship, the thing is that the son of the informant, who is Lordship a gangster, Lordship, more than Lordship 30 cases is pending against him, Lordship, in different court of Assam. There, all these cases are Lordship Dakari and murder case. On that, Lordship will see, he has mentioned that he went out at 8:30 p.m. and while he returned back at 2 p.m. Lordship, it is unbelievable. At 2 p.m., Lordship, who will Lordship ambushing to kill a person, and these 2 persons are neighbor, Lordship. They were not in talking terms at all with this son of the prisoner because he is a gangster, Lordship. Everyone knows of that locality. He Lordship create the unrest in the situation every day. He never roam without any arms, Lordship. He is always having an arms, Lordship. Arms or deadly weapon with him, Lordship. So under this circumstances, Lordship, it cannot be believed, Lordship, that this person, 2 persons who are Lordship in relation to this petitioner, sir, the uncle and nephew, Lordship. They are neighbors of this the son of the informant because they were not talking terms with that family because everyone knows that family, Lordship. So the neighbors have no talking terms with this family, Lordship. As a Lordship, gas Lordship, probably Lordship, this affair, they have named this affair.
Because he has also mentioned the one person pushing his car, pushing his bike. Who was the person, Lordship? Who was the person pushing his bike? Why his name was not mentioned in the FIR? It is very, Lordship, it is very doubtful FIR, Lordship, because of enmity, Lordship. This FIR has been lodged against us to harass us only. Because more than 30 cases is pending against this son of the informant. All are Dakai and murder cases. So for timing, Lordship, I may protect, Lordship, we are ready to cooperate with the all investigation, Lordship. Two cases are same, Lordship.
Is there, Lordship? Well, murder, Lordship. So let's
Not
see, Lord-
murder.
But we cannot say at the moment, Lordship.
Not
A young boy have died. Whether he
he
was
died, but no, it's not died. The murder is not only
Murder.
118, one is there. 109 is there.
today, as per Dr.
grievous heart is
still
there only
there,
one.
Lordship, because he's extremely critical condition.
This is a language
So-
loss.
So still, Lordship, we'll have to see, Lordship, whether he's what is his condition. Medical report may be called for, Lordship.
Lordship will call for everything, Lordship, no issue, Lordship. Only thing is that, Lordship, this is
Let
the
us
person.
see a short date, Lordship. It's
Yeah.
from Baksa, Lordship.
There might be, Lordship, some rival party against the petitioner because he is a gangster, Lordship. I'm also mentioning my petition also. More than 30 cases of all Dakai and murder is pending. So it is not a Lordship, I'm not suppressing anything. Might be that rival parties have attack him, Lordship. And because of enmity,
there,
our name has
Lordship?
been.
Lordship, maybe any other person may attack him, but
Lordship.
your name is specifically mentioned here.
Mentioned.
You are the
Mentioned because
person,
they are, we are neighbor, Lordship.
but I don't know. But as and it may be admitted also he may be a gangster or he may
Lord.
move along and always with arms or
Lord.
everything may be there. He may involve on because CD will reveal that he is if he is involved in other dacoit and murder cases. Maybe
Lord.
we are not on that. But the question is that he sustained a very serious injury. And this is against you only, specifically against you, that you too assaulted him.
Lord.
Because of a neighbor and all. Well, I don't know. You are maybe neighbor, there may be some quarrel or everything there may be because he is a person like a gangster or whatever.
Lordship.
So let your
Lordship will
yeah,
have the opportunity to dispute my application, Lordship. If Lordship find anything in the police report, Lordship will have the
Baksa, 17. What the matters we are listing it on 17 too, along with medical.
Lordship.
on 17 Lordship.
17.
Lord.
17.
All right.
16 and 17. Do it again order.
May I please?
Yes,
Page 19 in the FIR, there are 22% have been named in the FIR, 22%. And the text of the FIR is page 20. But what happened? This informant, this case is FIR arises out of the FIR lodged by this Abdul Hakim Ahmed, who has constructed and obstructed the embankment road spread to east and to west side, and constructing a house. They have let out the houses and shopping complex to the different tenants, which has been objected by the the person, those who use the road. And on 14/12/22/25, for which the FIR was lodged against all the petitioners, that there was a threatening from them. Then on 15/12/25, there is allegation that at night 10:30, the large number of people entered to their complex and assaulted specifically 1, 2, 3, 7 of the accused person number 1, 2, 3, 7. Specifically mentioned 3 persons, namely such and such and such. So case has been registered under 109, 118, 1090, 191, 1913, 1291.
Where you were from? You are saying this specifically, this his name mentioned.
But in the
Acha.
page 20,
Sharp.
the accused person number 1, 2, 3, 7 injured with sharp weapon. 3 persons. So, I am in petition number 7 and 19,
You are 7.
7 and 19, No, I'm sorry, not 7. I'm in 11 and 19. Abbasuddin, Yes, 11 and 19. Out of the list, So, I pray that the CD may be called for the medical report, and we may be given protection. They went to object the construction of an obstruction of the road, embankment road,
It was a road.
Yes, road, embankment, there is a road used by the people, They have obstructed it by constructing houses, shopping complex, and it was even rent out. It has come up in their affair itself.
Embankment you are using as a road.
Yes. That is the complex and enjoying these houses. Some of the shopping complex have been let out on rent. Rented by on rent. By occupying the government land matter. That's why people objected that that is the outcome of this affair. Maybe there was a market matter, I admit merit, but they have specifically named 1, 2, 3, and 7 only, who have specifically injured the accused person with sharp weapon. So I don't fall under this 1, 2, and 3, 7.
Page number 23, Lordship, earlier rejected by Session Court, Lordship.
Yes.
So investigation is at the
Rejected, that's why we have come here.
CDB there, Lordship. Let the CDB there.
The CD I am about to break. CD must come. CD is along with medical report. Point one, there is a specific charge from the informant that 1, 2, 3, and 7 have caused the injuries.
They are all FIR name accused person.
Yes, I admit my name is in there.
Let the CDB there, Lordship.
That's why CD. Otherwise, I would not have come here.
Mr. S.C. Biswas, Tilani counsel for the petition. Ms. A. Begum, Tilani PP. This is an application under section so and so information. Next prior is submitted by Mr. Biswas, the representative accused petitions are innocent. They have not committed any such offense as the alleged here. It is a fact that there was a quarrel which took place between some persons and the informant as he closed the embankment road by which these local people used to come and but lots of people gathered and an incident had happened. But in the FIR, it specifically mentioned that accused number 1, 2, 3, and 7 had assaulted the petitioner and his family members with sharp object. But full stop. But these two petitioners are petitioner number 11 and 19 as per the list of the accused persons in the FIR, and they have not committed any such offense as a different. However, they are ready and willing to extend their cooperation in further investigation of this case if they are granted with some interpretation. Next, MS Begum, Tilani additional PP raised objection and submitted that these two petitioners are also the FIR named accused person who are also involved in the alleged offense, and hence he submitted that the CD will reveal the actual fact and insisted to call for this case. Next part, considering the submission made by London Council for Business, other matters in the case. Appointed a petition to extend the privilege of interim pre-arrest bail to these two petitioners till the disposal, till the receipt of the test. Okay, will be under interim protection. Yes, maybe they get a matter. 9th of March.
Diplomat.
Appear before the IU within 7
days.
May I please, Lord? Two petitioners before your lordship, they are father-in-law and son-in-law before your lordship. And allegation against the petitioner is that they jointly went to the house of the informant and tried to outrage the modesty of the informant, lordship. Lordship, kindly see the FIR first, lordship, page 16, lordship, particular questions. This is type copy, lordship, kindly. Page 16. সম্মানপূর্বক বিনীত নিবেদন এই যে যোৱা 20/12/2025 তাৰিখে ৰাতি 10:30 বজাত মোৰ স্বামী আমাৰ গাঁৱতে চলি থকা ধৰ্মীয় সভাত গৈছিলে আৰু মই অকলে এটা কথাত তলা মাৰি আনটো কথাত শুই আছো। ইমান তাৰিখে ৰাতি 1:30 মান বজাত নিম্নলিখিত আসামীগণে আমাৰ চৌধত সোমাই আৰু 1 নং আৰু 2 নং আসামীগণে মোৰ ঘৰত দরজা ধাক্কা দি আমাৰ কোঠাত সোমাই আৰু মোৰ কাপোৰ কানি ছিঙি মোক ধৰ্ষণ কৰাৰ চেষ্টা কৰে। এনেতে মই বাধা দিয়াত মোৰ মুখত সোপা দি মূৰত আঘাত কৰি ফলত মই অজ্ঞান হৈ পৰোঁ। পিছত ৰাতি 2টামান বজাত মোৰ স্বামী ঘৰত অহাত জানিব পাৰোঁ যে মোৰ তলা মাৰা ঘৰৰ তলা ভংগ অৱস্থাত আছে। পিছত চোৱা চিতা কৰাত জানিব পাৰোঁ যে উক্ত ঘৰৰ পৰা মোৰ বিল্ডিং ঠিকাদাৰ স্বামীয়ে লেবাৰ পেমেন্টৰ বাবে ৰখা নগদ 1 লাখ টকা আৰু 2টা সোণৰ নেকলেছ জমিত নথি-পত্ৰ, আধাৰ কাৰ্ড, পেন কাৰ্ড আদি নাই। The entire incident shown to have occurred, Lordship, within 30 minutes. And the present petitioner before you is husband, son-in-law and father-in-law. Actually, what happened, Lordship?
Son-in-law and father-in-law of whom? This lady?
No, Lordship.
Who's?
Between the petitioner number 1 and
Accused person, Lordship.
accused person. Lordship, kindly see I have not annexed 1 copy. Actually, what happened, Lordship? The informant is the own younger sister's wife of the petitioner number 1. And Lordship,
Old younger sister?
wife, informant.
Informant is the?
Younger brother's wife of the petitioner number 1. And
Yeah, that means
and this affair, Lordship,
sister-in-law.
Sister-in-law, yes, sir. Actually, what happened, Lordship? The petitioner's wife, petitioner number 1's wife, Lordship, had lodged an FIR against the son of the petitioner informant, Lordship, under section POCSO, Lordship, all the section of POCSO, and this is the FIR, Lordship. And in that cases, Lordship, pursuant to the FIR, the son of the petitioner was arrested and trial is going on, Lordship. We have mentioned in my para 6, Lordship, but FIR could not be annexed, Lordship, and kindly
Is
see,
it
Lordship.
legible?
Yes, Lordship. Here it is mentioned.
POCSO cases number?
Numbered, Lordship, we have mentioned para 6, Lordship, para 6. Dhubri Police Station case number 333, 2005. That case was.
333 of 2023.
And a special case number also mentioned, Lordship, 251/23. This is going on against the son of the informant, Lordship, pursuant to my FIR lodged by my wife, Lordship. And in retaliation,
in
yes,
23 only.
Yes, Lordship, 23.
Your matter is of 2025.
5, Lordship, because now they are pressurizing to settle the matter, Lordship. And in retaliation, Lordship, to compel to settle the matter, Lordship, this FIR has been filed. And allegation is to outrage the modesty, not rape also. And my own younger sister wife, how it is possible, Lordship? Absolutely false allegation, Lordship. And petitioners number 1 and 2 are, Lordship, father-in-law and son-in-law.
That is also possible.
So, Lordship, till CD we may be protected, Lordship. Absolutely. In retaliation, Lordship.
It seems that this case may not be, I don't know.
Let the city be there, Lordship.
But bit pretty, I mean, thing is. Anyway, Mr. You are Mr.
80 short.
Sorry, 80 Sarkar, the learned also for the petitioner, and also had MSA become the learned additional PP application on. This is an application under section so and so in connection with so and so. Next prior is submitted by Mr. Sarkar that the present accused petitioners are innocent, that they have not committed any such offense as it is in the FIR. For the petition number 1 and 2 are the father-in-law and son-in-law in relation, and it's not possible that these two persons will visit in the night of 1:30 p.m. in the house of the informant to commit such. He submitted that case is the concocted one, and it has been filed only as a counterblast of case which has been lodged by the wife of the petitioner number 1 with the allegation that the son of the informant had sexually assaulted their younger daughter, that minor daughter, and for which 1 2 previous case number 333/2023 was registered, and at present, the POCSO case is also pending against the son of the informant. The informant side had pressurized to compromise the matter, and on their refusal only, the present FIR has been lodged with some false and concocted allegation. However, both the petitioners are ready and willing to answer. Okay, you will be under interim protection, appear before the IO within.
My objection may be recorded.
Yes, sorry, sir. Within 7 days from the date of MS A become the analytical proper liquido. Learned edition PP raised objection and submitted that in the as per the allegation, both the accused petitioners have come to committed rape and the outraged modesty of a woman in the night, and hence she submitted that CD may be called for to know the actual fact of the case and accordingly raise objection. 8th of March.
8.
Sorry, 10th of March. Am I your particular? It's hard to put yes.
May I please, your lordship? Lordship, I take your lordship to an additional affidavit filed today, page 35. Page 35. This is the FIR, my lord. And in the FIR, it is stated that the allegation against the petitioner is only that he is suspect that the petitioner has some, my lord, financial transaction with the, my lord, victim, my lord. Page 35.
Yes, what you're saying? Yes, I have.
Page 35, my lord. That is the FIR, my lord. Only allegation under section 103 and my lord 35, my lord. Petitioner involvement, my lord, cited in the, my lord, FIR is that, my lord, the petitioner has some financial transaction with the, my lord, victim. And the, my lord, victim proceeded to the house of the accused number 1, was arrested and was released on bail, my lord. Nothing more, my lord. Lordship, kindly see FIR, page 35. May I read? I, the undersigned informant, most respectfully submit that my nephew so-and-so, namely Saiful, aged about 24 years, by profession a dyno mechanic, was engaged in business relating to line trade with state of Mizoram and Manipur. On 26/9/2025 at about 3:30 p.m., he left his residence riding his motorcycle number so-and-so to go to the house of accused number 1. Accused number 1, I'm not accused number 1, for demanding payment of money due to him, but he did not return home thereafter. Despite extensive searches conducted by us and other relatives at various places, no trace of my nephew could be found. And subsequently, on 2/10/2025, we received information that a dead body was raped in Sek was lying under a bridge at place known as Nurkoli under Sorospur Police Station, District Hailakandi. Whereupon, we rushed to the spot and identified the body as that of my nephew Muhammad Saiful. Upon examination, injuries caused by sharp weapon, mark strangulation of neck, and acid mark of different parts of the body were noticed. After which the police recovered the dead body from the place of occurrence and sent to Hailakandi Civil Hospital for postmortem examination. And thereafter, the motorcycle of my nephew bearing number so-and-so was found abandoned on the roadside in front of Hailakandi Police Station, Shodor Police Station. Therefore, I firmly believe that the accused number 1 and 2, acting in furtherance of their common intention and pursuant to criminal conspiracy, deliberately murdered my nephew and thereafter attempted to conceal the evidence by packing his dead body in a sack, thrown it under the bridge due to financial transaction. Having no alternative, today I reached police station and drafted the FIR as per my instruction and filed the same. Delay was due to engagement in search of my nephew. So, my lord, only allegation that on suspicion my name was given. And accused number 1 was already granted bail, my lord, in page 21. Page 21 of my bail application, ma'am. From page 20, it starts, ma'am. Page 21, last but one paragraphs, it appears that the investigation is completed And the IO has arrived at the conclusion that the accused Bilaluddin, accused number 1, Bilal Ahmed, abated the commission of the alleged offense of murder. However, as the accused has under detention for considerable length time and investigation is completed, I do not find sufficient ground for his further custodial detention. Accordingly, the accused Bilal Ahmed is allowed to release on bail of rupees so and so with one suitable surety of like amount to the satisfaction of so and so. My lord, investigation, according to my lord, the IO, my lord, investigation is already completed. I will appear before the my lord, before the IO, and my lord, my statement will be recorded, my lord. On that day, my lord, lordship will consider whether any involvement is there, my lord. I may be protected for the time being.
Lordship, whether that it is surseated or not, I have to see, because it is 90 days. I have completed his investigation, Lordship. So as per the records, Lordship,
my submission will be
fix on tomorrow, Lordship. We'll see whether
No, 90 days is for that person only.
Yes, my lord.
no. If it is surseated, Lordship, his name is there in the. He is behind the bar, but
No,
whether
he's
he's
not
in,
behind him.
I'm not behind
no. Accused number 1, who is under after 90 days, who has granted bail. So
He was granted bail merely because he was an HIV
HIV
positive and
positive,
90 days
and
was
no,
there.
in that Lordship, in that regard, it is submitted that IO has it appears that the investigation is completed. So in
Showing him as an absconder also.
Lordship, for that.
My lord, charge sheet has not been filed. My instruction.
Then Lordship, CD will be required.
I'll appear before the
Then
IO. CD may be called. I'll appear
The
before the IO.
person was very brutally killed.
Lord-
Even after killing
But so far the allegation, but so far the allegation against the petitioner is concerned, my lord. That is, my lord.
Okay, we'll call for the case diary when it can be fixed. It has to come from which place?
From Hailakandi, Lordship.
Hailakandi.
19,
Some
Lordship?
time.
19?
19.
19.
CDP.
Obliges.
Okay.
My lord.
Yes.
FIR in page number 15, my lord.
15.
15, my lord. It's a translated copy, my lord. The my lord, fact is that, my lord, operative part start from the page number 16, my lord. The brief incident is yesterday that on 16/1/2026 at around 1:45 p.m. My lord, kindly note the time, my lord. I went to attend after that ceremony of neighbor. The accused number 1, Kamal Das, reached the ceremony and without having any reason. My allegations that I have reached the that ceremony and without any reason started using the slang language when I opposed to the accused physically assaulted me. I assaulted her in that ceremony. Pull off my clothes and grabbed me by hair and throw me to the ground. Somehow I escaped the situation and come out from the place. The accused number 1 along with the accused number 2 intentionally hit me back from the vehicle bearing number such and such. The second allegation, my lord. My right hand was broken. The accused did not stop there. The accused with intent to kill me again hit me from the backside of the vehicle. A man, namely such and such, who was near me, was seriously injured during the attempt. The public gathered the place. Then the accused person fled. My lord, in the death ceremony, and subsequently the public gather on that situation. My lord. So all the false allegations, my lord, actually sees next door neighbor of me, and there is a land dispute, my lord. She also admitted later on, my lord, the accused number 1 and 2 are my neighbor, and the accused number 1 frequently makes options gestures to me, and that for that frequently engage in the argument with me. That is not the fact. Actually, fact is that there is a land dispute. Because of that land dispute, there is a argument between the parties, man. And all the false allegations, my lord. And in this situation, CD may be called for, my lord. In the meantime, my lord, I may be protected. I am ready to give my statement.
Because our hand is broken, Lordship. Complainant hand is broken.
That is the allegations, my lord.
See the report,
All are the allegations. In the meantime, my custodial interrogation is not required in this matter. My lord, I am ready to obey with all the conditions, man. All the conditions, whatever conditions this court.
Lordship, we see the complainant went to a funeral ceremony of his neighbor at that time. The accused now assaulted her with a slang language to a lady, Lordship.
Okay.
And the allegations is contradictory to each other.
Lordship, it is Barpeta 17, Lordship.
17.
In the meantime, I would ma'am kindly.
Oh. This is what? 21. Hearing. Oh, see, it's the building. You got family.
Seven, well, as many as 20 persons are accused, and the accused petitioner is at serial number 18. The allegation is that one person was killed, my lord.
Your
But
petitioner is serial number 15.
yes, I am at serial number 18.
18.
18.
My lord, the ground taken by the petitioner is that he was not present. Plea of alibi is there. He is a businessman of Jalukbari area and he is residing there. Plea of alibi is there, my lord. He was not present in the occurrence and not involved at all in the case, my lord. Lordship may see the records, my lord, case diary, my lord, whether he is involved or not, my lord. Not at all involved, my lord.
CD on Lordship, it is from Kamrup, Lordship, 17, Lordship.
Well. How? I bail matter.
Lordship, offense of rape, Lordship, CD may be called for and the matter may be taken about 20th February.
20.
20.
CDP called. Okay, well, listing it on 20th February.
20.
20.
20.
20.
May I please, your lordship? Lordship, in this case, the complainant had approached the SDJM Bukakhat to file a complaint case, lordship, CR1 of 26. Now, lordship, in this case, the learned SDJM Golaghat, he passed an order directing the police to register an FIR. The police later registered an FIR under section 69. Lordship, the main allegation in this case is that the order is on page 17, lordship, if I may read, lordship.
Yes.
Here. The complaint petition filed by the complainant alleging commission of offences punishable under section 69, 89, and 319 of BNS 2023 has been produced. Upon a careful consideration of the averments made in the complaint, this court finds that the complainant alleges that the accused, by employing deceitful means and false promise of marriage, entered into a sexual relationship with her and thereafter administered medicines resulting in termination of her pregnancy. At this stage, the court is not required or appropriate course at this stage. The court is also mindful that an order directing investigation under section 175 of the BNSS 2023 is to be passed only upon application of the judicial mind and not as a matter of routine. Having applied such consideration, this court is satisfied that the police investigation is necessary for the end of justice to ascertain the truth or otherwise of the allegations. Lordship, now the petitioner and the complainant in this case, they were in a relationship, but they broke off amicably, lordship. Now the petitioner is ready to appear before the IO, lordship. So, lordship, case there may be called, and in the meantime, he may be given protection to appear before the IO, so the investigation may be proceeded with.
Lordship, it is a false promise to marriage, Lordship. There is termination of pregnancy. The thing is that, Lordship.
The thing is that nothing has been proven so far, and no evidence has been. So, lordship, investigation may be allowed to continue, and he may be allowed to appear before the IO so that he may present his side, lordship. This is my humble prayer, lord.
Only due to the termination of pregnancy, Lordship.
But lordship, still, she has not presented any evidence, lordship. That has been recorded by the court that she seeks to rely upon. She has not presented the evidence, lord.
Administered pregnancy, but she was not in a position to collect the electronic evidence and all, because she was not in a position to show. So that in that circumstances, only considering the entire facts,
he may be allowed
consider that the police investigation may be required.
Yes, ma'am.
With that observation only, that it is not a case that she was not in she could not file produce any evidence and all. These are not the case. This is case. The overall consideration was there, and accordingly it was sent for police investigation. That's
That is why I'm asking Lordship, he may be allowed to appear before the IO to present his side, and if any evidence he has, Lordship. And the CD may be called for.
What is your case? What do you want to submit here?
Lordship, I want to submit that the police has been.
FIR or complaint?
FIR, Lordship, no, actually, Lordship, no FIR has been presented. On
No,
basis,
the complaint is?
Lordship,
Where is the complaint?
Where is the complaint?
Lordship, the complaint, the FIR has been registered on the basis of this order, Lordship.
Where is the
FIR is
There was a complaint, on the complaint was sent for investigation by the particular order which you have read.
Lordship.
So where is the complaint? Where is the FIR? From where we are saying?
Lordship, the
There's
FIR,
nothing in the record.
Lordship, a complaint has not been given to me, Lordship. They were not able to take out the complaint, Lordship.
Then Lordship, how can this be done?
How can you
Then
file
we
your
have-
complaint then additionally?
He may be allowed to be appear before the IO. The
Your-
maintain
your
protection may
good
be
name?
given.
Heard Mr. Learned counsel for the petitioner and also heard MSK so and so. During the course of argument, it is seen that the case is not supported, the petition is not supported with the complaint or the FIR, under which, on basis of which the case was registered. In view of this, the petitioner is hereby directed to produce the complaint of the FIR through an additional evidence. In the next date of listing, list accordingly on, and we are listing it on the 12th of February. 12th of February.
Well, Lordship, maybe sometime later, maybe 16.
16?
16.
16.
Right.
Yes. Any information?
As far as Lordship not yet submitted in.
So your petitioner is in 85.
56 days, Lordship.
Huh?
56 days behind the bar. 60 days is mandatory period in this case.
Your petitioner is behind the bar since when? 50?
2012-25, my lord.
15-12, Lordship. 15-12.
Huh?
15-12-2025.
15-12.
15. 56 days.
56 days.
6 days.
What nature of case?
Fake gold.
Under section 61 to criminal
Drum. Petroleum or what?
fake gold, Lordship.
Oh, fake.
Fake gold sold and purchased by
This from
some
again from Lakhimpur, Hedi?
Yes, Lakhimpur.
But I am not in the FIR named.
Lakhimpur, that means Lakhimpur is with the gold.
Yes,
Na?
yes, ma'am. The entire record is
Everywhere
from-
there's gold and gold and gold
Yes,
everywhere.
yes. Entire machine, equipment, everything,
Everything is from
Lakhimpur.
Bihuria, Lakhimpur.
Bihuria.
Why your petitioners choose
Lordship,
that
I am
place
not
only?
FIR
Why
named accused.
Lakhimpur is chosen?
I have no.
In every case, such kind of case where fake gold is involved,
Yes,
every
sir.
case is jurisdiction
The
of the.
present petitioner no way connected in this case, Lordship. In the
You
forwarding
just
itself.
ask your petitioner why they have choose the Lakhimpur
Lordship,
area.
Yes.
Heard Mr. A.B.T. Sheikh Hawk, sorry, and counsel for petitioner. Heard Mr. P. Potaku, Delaney additional PP, appearing state respondent. This is an application description so and so in connection with so and so. Is submitted by Mr. Hawk that the present petitioner is Muslim and he is not connected in the LS bonds and his name is also not mentioned in the FIR nor there is any implication against him in the forwarding report. However, the petitioner is in custody since 15/12/2025, that is 56 days in custody, and hence, considering his period of detention, he may be released. The petitioner will extend his cooperation in the further investigation of this case if he is granted with privilege. Next one, Mr. Potaku, Delaney additional PP submitted in this regard. That from the according report itself, it is seen that there are sufficient materials against the present petitioner, but on inquiry, it is found that the charge sheet is not yet is not yet filed by the IO, and the case is still under investigation. Next, para hearing the submission made by learning counsel sides, without going detail into the merit of the case, only considering the length of detention only undergone by the accused petitioner I find that further custodial detention may not be required for the purpose of investigation in view of this one. Your cases where from? It is cases?
Not
Oh, Lakhimpur, not.
Yes.
CGM, Lakhimpur, not. Okay, we're granted.
Six.
Lordship,
Okay. It will be-
26, my lord, actually AB, my lord.
It is AB.
AB, my lord. Although, my lord, listed in bail hearing, my lord.
Oh,
can it
anyway,
be taken after a little while? Mr. Nawaz is on break.
after timing. You have received the case.
It is case they received.
Okay.
Obliged.
27, my lord, case diary not yet received, my lord.
Not received.
103 is there.
103 is there.
Yes,
Where from it has to come?
from Kamrup, my lord. Kamrup Metro.
My lord, this is second time, my lord. It was earlier listed,
Time, man. Means
my lord, on
earlier is it-
51.
earlier-
I won, then fix on
So initially, my lord, CD was called only on 7/1.
This is the second date, I think.
Second time.
I mean second, not second date.
Second day, yes, from second.
Oh, acha, where is the order of 3-2 then?
5-1 it was listed, my lord.
Okay, 3-2. 3-2 order to 9.
7/1.
9. 3-2.
7-1 list. It was listed on 7-1, my lord. Then fixed on 3rd February, my lord. On 3rd February, there was no court,
Acha, no court was.
lordship. That is why fixed today, lordship. On that day, the court could not sit, lordship. But lordship,
Where from it has to come?
it's from Hajo, my lord.
Hajo, my lord.
Well, only he is not named in the FI, my lord. He has surrendered before the investigating authority, my lord. He fixed marriage with the deceased victim girl.
She died, na?
She died. And her courtyard, my lord. His house is far away from his house, lordship.
Let us see whose his involvement if anything is there. When it can
He is
17 to
17?
2.
17
2 will do.
lordship.
He is in custody since when?
Since lordship on 2012 to 2025 for about
12.
lordship 51 days. 51 days.
We listing it on 17 to let Perus the case die. CDB not received, issue reminder with a direction to the police authority to furnish the case diary on or before the next date of listing on 17 to 11.
Lordship. Obliged to lordship.
What is the position of 28? It is a scan copy?
Lordship.
Charge sheeted case?
Charge sheeted case, Lordship.
Lordship, the matter may be adjourned for the time being. The leading advocate is in another court.
Okay.
My lord, I am in jail for. My lord, your lordship kindly see already, my lord, main accused has been granted bail by the London court below, my lord. My lord, I am a student. Your lordship will. FIS page 13, my lord. Allegation is that, my lord, from the forwarding report I came to know, but my friend, my lord, he used my handset, putting his, my lord, his SIM card. The handset is mine, my lord. He asked for the handset. I have given it to him, my lord, and putting his, my lord, SIM card in my phone, my lord. He used it, my lord. Some money has been transferred from account of the complainant, my lord. So he has been arrested and he has been granted bail by the London court below. Now I am in jail, my lord. And he is a student of 19 years, my lord. I have annexed the ID card also, my lord. Money, huh? And today already 48 days, my lord. Managing Ishopali.
But there are 45 transactions.
43
My lord.
Let the city.
No, that is, this is a 439, my lord.
custodial lien. I'm in jail, my lord, and already, my lord, the main accused, who has, my lord, used this, who has done it, my lord, he has granted bail by the court below. Because I have opposed this honorable court, I am, my lord. My lord, I don't think that the custodial litigation is required, my lord.
May request a bail order to
Listen.
take the jail order.
Fair name, comment. Isopali is the main person who used this, my lord.
Since when you were in custody?
I am in custody, my lord, from my lord, 24/12. Today is exactly 49 days, my lord. Nineteen-year-old boy, student, my lord, he is in jail, my lord. Probably if he in jail, my lord, he'll be come out with him, my lord, get criminal, my lord. Because of one mistake. Yes, he has committed a mistake to given his handset to the, my lord, his one of his to his friend, my lord.
It's okay, it is your submission, but where from we'll see that it is the
What
case
is-
that
no, your
you
lordship.
file your.
My
You,
lord.
you submitted, I mean,
No, I am not
taking
submitted from my own. I am submitted from my record, my lord. Your lordship kindly see.
record, yes.
My lord.
Yes.
The forwarding report, my lord.
Forwarding report, at
My
is
lord.
that page?
Page, my lord, 20.
Yes, what is it? During, in the course of investigation.
Yes, my lord.
Hmm.
With reference to cited survey, I would like to inform that the brief of the case is that on 27/12/2025, complainant of the in case namely SI Harendra Nath son of Hemen Nath, son of the so Nath will be district Borpata Assam laws and FIR 3S stating that on 23/11/2020 about 5 complainant to the Disney Bazaar for making his mobile phone along with his SIM card number stolen away by from some unknown miscreant culprit. After forward, when she went to the withdraw money from the Union Bank of account number so the ATM, he could came to know that from the his above noted account, some unknown culprit transferred a large number of money amounting to rupees 2,94,993 and SBI account amounting to rupees 7,700. So a UPI different account, hence the above reference case is registered and the investigation is proceeding. In course of the investigation, in case they revealed that the thief not also stole the mobile, but the somehow accessed into the UPI account of the UPI app of the stolen mobile phone, withdraw a huge amount of hard-earned money of the victim in this case. The thief withdraw his money throughout the 43 UPI transaction different bank account during the investigation. One of the account holder, namely Ishaq Ali, so with a so whose SBI account by number so and so 3,000 was credited from the victim account number so and so. In course of investigation, Ishaq Ali was arrested and from his revealed that during the time of transaction of the said money from the victim account for UPI SIM card of Ishaq Ali was inserted into one Farooq Abdullah's phone. I am Farooq Abdullah. So Ishaq Ali was inserted in one Farooq Abdullah's phone. Accordingly, Farooq Abdullah was apprehended on examination of the CDR of the SIM card of the so and so. So I was arrested because my handset will be arrested.
Okay.
Now this Ishaq Ali has granted bail, my lord. So from that, my lord, I am submitting, my lord. The mobile phone of the Farooq Abdullah is duly seized. And Farooq Abdullah, according to bank account, was also arrested. Account is showing case. So, my lord, my submission before your lordship, my lord, ground of arrest, your lordship kindly see. My lord, ground of arrest, my lord, your lordship kindly see. Next page, page 21.
Yes.
They revealed that the accounts of arrested accused Ishop Ali amount of rupees 3,000 was credited from the accounts of victim Harendranath so and so. Ishop Ali phone number so and so and according to so and so was used arrest of account Farooq Abdullah at the time of his said transaction. So my only handset is being used by arrested accused person. The arrested accused person who has close link with arrested accused Mr. Ishop Ali and another co-accused Zahirul Islam who is yet to be apprehended. Under the above circumstance, I paid your honor to that the arrested accused person may not be kindly be released on bail, and he may also be remain in police custody for a period of 4 days for further investigation. As under stolen mobile phone of the complainant is yet to be recovered, and the accused Zahirul Islam as another person yet to be recovered. So and so, so and so. So these are the allegations, my lord. Against me, only allegation that my handset has been used, my lord. So that is a mistake I have committed, my lord. I admit it.
It is no.
So he has already been granted by Ishop Ali.
Number the other.
I am a student. You will kindly see.
Transacted.
Lord.
There's no mention at all. 3,000 is mentioning here whether this account of the present accused person any money was transferred. That is also not
see from the CD, lordship. That is the thing, lordship, because his phone is used for what purpose, lordship? Let the CD be used.
No, my phone is not, my handset is used, not SIM card is not mine, my lord. SIM card of the Ishop Ali, my lord.
The SIM card is of him, but the let us see the CD, lordship, because the amount is.
Your lordship kindly say long date was given in the first date. Today they are unable to pay, but just because I am opposing them, that's why I am in jail, my lord.
28 lordship, last date, lordship was short date, lordship, this week only.
My lord, this is not the period. That's why I am submitting, my lord. Your lordship kindly see how the investigate. Your lordship kindly see the order, my lord. That order I have a next, my lord. No, if he will not be a student, I am not my proceeding such, my lord. All right, let them produce it tomorrow, my lord. I am ready to go there tomorrow, my lord.
No.
Your petitioner is studying what?
Yes, my lord, high secondary student, my lord. Your lordship kindly see, came academy, 19-year-old. He is a betterment examination in the month of February, my lord. If my learned friend opposing them, let me tomorrow, my lord, by special messenger, my lord. I am not that, my lord. I am parity. I am stating, my lord. The person who is the only, who is the main accused, he has granted bail by the court below. It is my bad luck that I am opposing this honorable court, my lord. Because of his student at that time, my lord, yes, they said that early the next day they will produce the case there. At that time, on that consideration, I am not paying for any interim, my lord. Yes, if my learned friend says that tomorrow he can produce the case there, I have no objection. But my lord, a student, my lord, your lordship kindly says, yes, I admit it, I have committed a mistake. The person who is the real, my lord, culprit, he has already granted bail.
Mr. T.J. Mahanta, Delanate Senior Advocate, assisted with IMSP PROCEEDINGS, Delanate Constitution, North Department, A. Begum, Delanate PP, appearing on the it's an application at section so and so. C did not receive, and it is submitted by MS Begum that no intimation has been received from the IO as to why the CD could not be produced to be. Next, Mr. Mahanta, Delanate Senior Advocate, submitted in this regard that the present accused petitioner is innocent and he is no way involved in the alleged offense. It is only case against the present accused petitioner that the co-accused, namely Ishop Ali, had borrowed his mobile handset, and on good faith he handed over his handset, and in the said handset, the co-accused Ishop Ali had inserted SIM, and the transaction of money was accordingly done by him. He submitted that it is from the forwarding report of the present accused petitioner, it reveals that during the investigation, it has come out that only this SIM was inserted in the mobile handset of the present accused petitioner. Apart from that, there is no other involvement in the involvement of the present accused petitioner. Mr. Mohanto further submitted that the present accused petitioner is a student of higher secondary student and is only 19 years old boy, and his only mistake committed is that he handed over his mobile handset to the co-accused person. MSA Begum, the learned additional duty submitted in this regard that there is no mention about a transaction of money in the forwarding report, wherein the allegation is that there was a transaction about about 3 lakhs money was withdrawn from the account of the informant. Accordingly, it is submitted that CD will reveal the actual fact of the case, and CD will reveal and accordingly insisted fix another date. Mr. Mohanto submitted in this regard that the co-accused, the main accused of the present accused petitioner has already granted bail by the learned trial court below, considering his length of detention, and on the present petitioner, who was the main culprit of the present accused petitioner, is only involved in giving his mobile handset to the other co-accused person. However, the present accused petitioner is in custody since last 49 days, and thus police got sufficient time for his custodial interrogation, and hence further custodial interrogation will not be required for the purpose of investigation. However, he is still ready and willing to extend his cooperation in further investigation of this case if he is granted with the privilege. Next, further hearing this submission made by the considering the statement made in the forwarding report, wherefrom it reveals that the only involvement of the present accused petitioner was that his mobile handset was used in the alleged transaction by inserting a SIM. However, it is also admitted that the accused petitioner is in custody for considerable period of 49 days, and thus the IO got sufficient opportunity to interrogate the accused petitioner, keeping him in custody. Considering all these aspects of the case, especially the length of detention, find that further custodial interrogation may not be necessary for the interest of the investigation. However, the present petitioner is hereby and the direction extends. To whose satisfaction? Is this satisfaction of whose Bongaigaon?
SDJM Bizni mail.
SDJM Bizni. Satisfaction of
SDJM within bracket M Bizni Sirang. SDJM. M money.
M money Mofosol. SDJM M.
Yes. SDJM Bizni Sirang.
M means Mofosol is thing.
Mofosol, maybe.
Oh, yes.
Sorry, my yes, Mofosol. Deep level. Thank you.
Scan copy you have received here?
No, it is CD was called for, or 30 lecture. No,
30.
30 received that.
Yes.
May I please also? The phase of 483 will, this already custodian 163 days, both than husband and wife. Though they have the
charge sheet is filed under which section?
103.
103.
103.
Oh.
But not incident is not like this. It's if you go to the FIR, they will see that there was an arguing in with this is and this the accused persons. But we go to the page number 30.
13.
And 32. The cause of death is a heart attack. That's the result of the heart attack. Is the cause of opinion made in a result of the laboratory analysis to the opinion and medical examination. Death of was due to the synopsis of as a result of from coronary insufficiency. It's blood. This is a medical versions of the heart attack. We are already charged and already two witnesses already examined in our lower court sessions. Already name of this one, honorable Islam informant and the whose person, if the incident was placed in front of their house, the person was examined in the honorable session judge. We have three minor children. One children is with me, and there is an actually, my lord, what happened in page number 6. It will be narrated in our petitions that the prior to the LS incident, minor daughter of the accused Suraj Ali, the petitioners, was sexually assaulted by the rape by the one Baharul Islam, who is the son of the deceased Abul Hasim. A case regarding the same erroneous crime and duly registered the police authorized and said Baharul Islam is in presently judicial custody. But after the registration of POSCO case against this deceased Abul Hasim.
PM report annexed here.
Lordship, PM report is
PM report is
there.
annexed.
PM report is. Lordship.
Actually, my minor daughters was raped by this by son of this Islam, the Baharul Islam. Only for this this arguing is going on. Yes, definitely arguing is going on, but there is no any incident like started in affair. This is completely natural death, but they were putting me this. It is my 103. And these two girls already in my neighbor's house, not with me.
Kept pending till the receipt of the chemical analysis, FSL not. That. Let me see the FSL report.
Lordship, we go through the evidence of this petitioner, Anarul Islam.
If I see FSL report here, with PM report in the case record.
We have no knowledge. Yes, there.
Let's see this the injury where it is. The contusion seen on the left side of the neck, Lordship, in the injury part.
Because as per the there was a head injury.
Regarding poison, Lordship, no poison was found out.
It is okay. Poison is not there because it was the quality she became.
Lordship, there was an altercation between the deceased and the accused person. There is an altercation between the deceased and the accused person. Then they have first hit on the neck. Or that Lordship,
there is not neck.
Is seen on the left side of the neck. There was a hit, Lordship, according to the FIR. Then he fell down on the brick particle. Then immediately he became unconscious and he died on the spot.
This is not actually, my lord.
That is what I have submitted.
Yeah, sir. But if we go to the evidence of this PW 1 and 2, this will be clear, my lord.
According to evidence of 1 also, Lordship, that it is that there was altercation. Then it was our father was pushed and he fell on the brick and he became unconscious and he died. Evidence. And in PM report, injury was on the neck was there.
But in FIR, they did not discover the neck cover. They were said that they had injury, but there is no any head injury. In page number 19, FIR is there, my lord.
Wherefrom we are saying that it was a heart attack.
My lord, in page number 32, the result of laboratory, this is search it. The genomic coronary insufficiency. This is the medical versions of the heart attack.
Where in 32?
Page 32 in our petition. Result of laboratory analysis, expert opinion, medical examinations. Death was due to Shenkov as a result of from coronary insufficiency.
But in PM report, it is not there.
This was already.
Wherefrom it is seen, PM report is not there.
In PM report, it is
No,
not
no,
there.
my
This is what? Your charge sheet. This
our
is charge sheet or what?
Yes, search it, my lord.
Search it.
Though is there, my lord, if you go to the evidence of the 3W1 and 2, it will be clear, my lord. Going is oddly with the Suruzali, not the petition number 1, not the petition number 2. Petition number 2 at the time of incident, she was in her own house with her minor children's.
Only 2 witnesses are examined. Only let that.
Main examination, the information is also examined. In PW2, there is a very interesting. He came to his house. Already was FIR disclosed that he came to the Abdul Quddus Sodori's house. This was already been examined. He already informed that I know the accused persons. The incident took place August inside my house premises. Inside my house premises at about 3 p.m. Abul Hasim, this is the deceased, was visiting my home on the day of incident. I was working inside. Abul Hasim and accused persons were outside my house on road. I heard hue and cry. I saw Abul Hasim is lying on ground. He was on the verge of death. A crowd was gathered them. I know him. In his cross-examinations, he said Abul Hasim was lying alone on the ground inside my land. This incident is happening there outside my home, outside my boundary, but he was lying in my land. The ground where Abul Hasim was lying not concreted. This is a plain places. I do not know why Abul Hasim is lying on the ground. I saw Abul Hasim bleeding while lying on the ground. He was raised hue and cry.
So some more PWs must be examined.
Nothing is, this is one already Anarul Islam, who is the informant. He was already examined and he was already deposed in before evidence that Suruz Ali had a filed rape case against my brother Baharul Islam. In his their evidences was already examined. Already he is deposed. The Suruz Ali along with Marjina quarreled with my father. I was inside my house at the time of quarrel. Baharul's wife Masida was with my father. Suruz Ali punched my father on the side of his head. Marjina Khatun pushed my father on the ground. This was completely this one false statements. My father died instantly. Nearby people came to the place occurrence. My father's body was brought my home, and concerned Gaubura Asadul Islam was called to advise us to inform the police. In his cross-examinations, my lord, it was to be found that I was not present at the place of incident. I have not seen the actual incident. My father had left Abdul Quddus Master's house just before the incident. This was contradictory, my lord. This Abdul Hasim already says he came to my house, and he already said that he left my house. And another thing is the incident Rohima Khatun, Rohida Khatun, and present. One side Almira Hapni is informed me. When I reached the place incident, the accused person already reported. I crossed them while they're coming the incident. The place incident 20-30 meters away from my house. I reached the people incident just 2-3 minutes after my felon. The accused person's house is just near my home. He says there already many persons is there, but his if it PW2 it is that no one is there, only dead body is there. No person is there already. No gathering is there also. Just completely making case, my lord.
Only 2 PWs are played.
Or 160 minors
examined
Because
because
the case of when it was not so intentional, because it was a quarrel was going on, and in that moment that incident happened as he pushed and he fell down. Obviously there was a hit.
due to that hit he fell down, lordship. Due to the hit, and the hit was there. That neck means in back portion, when somebody they used to say head only, lordship, then it corroborates with the medical evidence, lordship. Confusion is there.
Further custodial is
At least 2-3
Two
more.
witnesses already, my lord, examined. But already two minor
Raising
children.
hue and cry. Neighbors came to the place. Then only, lordship, only now informant and one neighbor.
Like, who is the incident place in?
Eyewitnesses as per you?
Eyewitness is Abdul Quddus, my lord, who has in their house their incident was
See,
happening.
lordship, because now we are unable to test. Only 2 witnesses are examined, lordship.
In the entire circumstances you go by.
Lordship.
There was a quarrel.
There was a quarrel. Definitely, there was a fact is that there is a quarrel, and due to the heat, lordship. Otherwise, it's okay, fine. There may be altercation and one may push, but due to the assault in the neck part, lordship, he fell down.
The FIR is not disclosed, my
That is
lord.
there, lordship.
FIR is that hit my head.
And
But no, FIR is a very important
So,
part.
for you, who will be the other vital witnesses, if any? Do you?
Lordship.
Are there any other vital witnesses?
That we are now unable to say, lordship.
Do you think that there is any probability of tampering, or is there any other vital witnesses that has to be seen? Otherwise, how can you see?
Lordship.
At least
161 is not so important, lordship. Only it is for contradiction. So let us see at least 2 more witnesses, lordship. Then lordship may finally dispose of.
The main 2 witnesses already examined, my lord. This was the informant, and the incident where he places.
Case record. I mean, what I'm saying.
Case record is statement of 161, lordship.
That much, or you can go through. We can fix it
Lordship,
by.
then I'll see, lordship. Any 161, is there anything relevant
any
to
vital witness? We're listing it.
Lordship.
Not tomorrow, day after tomorrow, we are listing it on.
Lordship.
List on it. Day after tomorrow is what? Day after tomorrow is 11. We're listing it on.
My lord, if maybe fix on 12, my lord. Day after tomorrow, actually, my words like exam will be started high secondary final.
12th.
11th will be exam.
Oh. Yes. So you are saying that 12 maybe.
12th.
List on 12. In which case we are in? Yeah. Okay, we are listing it on 12. You just go through, is there any vital witness if required? This custodial interrogation is required or not? That much.
Lordship.
Highly oblivious.
31 with 32.
Yes, my lord. This case was similar with item number 3, my lord.
Similar with item number?
Today's list. Item number 3, my lord. Your lordship is granted bail, my lord. This is fake gold, my lord. Same FIR, my lord.
No, whatever. We granted on different context. That
yes, my lord. That is
considering the length of detention.
Yes,
Your petitioners are in behind the bars since when?
For 56 days.
Your 2 petitioners are also for 56 days.
One is 51 and one is 56 days.
Okay,
Yes, my lord, same,
same.
same.
But as per the this CD, there are materials, some materials are.
Yes, yes. And search sheet not yet submitted. Here, my lord, IO has submitted one application that my lord CD is in my lord CGM court, my lord Lakhimpur, in connection with some other case. So CD could not
CD
be.
could not be produced today.
Yes, yes.
Equity of heard Mr. M. Kalita, the learned counsel for the petitioners.
Here 51 days. In earlier case, my lord 56.
In both the matters, there are
No,
51, 51.
First case 56 days. 31,
31 is 56 days.
Another is 51.
51 and 56 করে দিব না এটা ডিলারের কনসিকুয়েন্স 30 বেলেগ বেলেগ কে একে কৰি দিও ফুটতে একে CD not received. It is decision application section Swens connection with Swens is submitted by Mr. Waterman as CD not received. As it is informed by the IO that the CD is lying for the court of CGM Doctor. In view of this, it is submitted to Mr. Kalita, the learned counsel petitioner submitted in this regard that the present petitioner is innocent and he is not reconnected in the alleged offense. However, he is in custody since last 56 days, and hence, considering his length of detention, he may be allowed to go. A total 51 হবে 50. It is further submitted by Mr. Kalita that the IO got sufficient opportunity to interrogate the accused petitioner, keeping him in custody, and hence further custodial detention may not be required for the purpose of investigation. Next one, Mr. Portapo, the learned PP submitted in this regard that he is not in a position to say much about the merit of the case, but from the forwarding report and other matters in the record, it is seen that the petitioner is also involved in the alleged offense. But he submitted that case is still under investigation and there is no probability of filing charges within 4 5 days. Considering so on the without going details of the merit of the case to the satisfaction of CGM, Dr. Bono. Are you to 51 is same section? Okay, your both the petitions are granted with bail, but there will be some conditions appear before the IO as and when it will be.
Lordship,
He's actually
on the way. So, Lordship, a date may be fixed, Lordship. Item number 28.
Because I have a meeting also, it will reach. 28.
28.
Otherwise, it was in motion. Motion.
No, Lordship, scan copy was there,
scan
Lordship.
copy was there. Actually, he's in the lobby. My lord.
Let the date.
Just now I have called him. He said that he
He's here.
Oh,
Yes, okay.
Oh, I by CD.
So scan copy you have received?
Received, Lordship.
Okay.
Oh,
28.
28. Total lot there is. And
Then
what
Lordship.
is it? PW.
12 Lordship.
12.
12. Until now, not a single witness has been examined, Lordship.
Infinity?
How many? How many?
12.
Listed witness 12. And
12
how many
listed.
already?
Not a single witness till now.
Not a single witness. That's it.
Lordship, then Lordship, total he is 324 days behind the bar. Since 22/3/2025.
Eyewitnesses are there, Lordship. The thing is that the eyewitnesses are there. FIR only will reflect everything, Lordship.
In this is what happened, Lordship. I am not basically on merit, Lordship. The charge sheet is laid. Then, Lordship, not a single witness has been examined till yet. Although charge was framed on 5/8/2025. 5/8/2025. Lot many deaths have already gone, Lordship. Lordship may kindly see The notice part, page 17.
Page 70.
17, 17.
17.
Type copy, Lordship, translated copy. Type copy. Here, Lordship, may kindly see the ground of arrest. 3 grounds have been cited, Lordship, but they cannot be, Lordship, termed to be ground of arrest. At best, they could be reason of arrest. As held in the Lordship case of Prohibitions, the Lordship, they are distinct things, Lordship. Ground of arrest, reason of arrest. No details of the case, nothing has been mentioned. First part is, Lordship, that case number and penal section. Then second part, Lordship, may can see ground of arrest. Number 1 ground, during the course of investigation so far progressed, sufficient evidence have been found against the arrested accused, indicating commission of the offense. This could at best be a reason of arrest. Then number 2, the weapon X is recovered, which was assaulted by you. Number 3, it is found that with a prior plan, full knowledge of the consequences and gravity of the nature of offense, you have committed the crime. So there is no details about the offense. And this is in violation of Lordship that Prohibitions, the Lordship judgment, where it has been held that the ground of arrest and reason of arrest are two distinct things, Lordship. They cannot be equated with each other, Lordship. In 47, the IO is required to submit, Lordship, furnish ground of arrest, not reason of arrest. Here, Lordship, nothing regarding the crime or the offense has been mentioned, Lordship. Then same thing goes with 48, Lordship, page number 20. Notice under section 48 BNSS. So it was furnished to the wife of the petitioner, Lordship. Same thing, Lordship, ground of arrest, Lordship, you can see down below. Number 1, Lordship, during the course of investigation so far progress, sufficient evidence have been found against the arrested accused person, indicating commission of the offense. Number 2, Lordship, the accused confessed his guilty and sufficient evidence were found against him. Number 3, Lordship, the accused with a prior plan having full knowledge of the consequences and gravity of the nature of offense committed the crime. No particulars regarding the offense. And then, Lordship, these are in complete violation of the settled proposition of law as laid down by the Honorable Supreme Court, Lordship. Then, Lordship, the delay in, Lordship, trial. Although a charge was framed on 5/8/2025, Lordship, till now several days have gone by, Lordship. Not a single witness have been examined, Lordship. And already the petitioner has been incarcerated for 324 days. So I am not basically on merit, Lordship. These are the grounds.
Eyewitnesses is there, Lordship. There are no
Where is the forwarding? Forwarding.
Forwarding,
Lordship.
I have a next page number, Lordship.
15,
50.
Lordship. 15. The third point, Lordship, during the course of interrogation, the accused admitted his guilt. During the course of investigation, the weapon X is recovered at the place of occurrence, which was assaulted by the accused. If the accused is not, that is Lordship. Then 7 point, Lordship, sufficient evidence are found against the accused person. The normal, but Lordship, the thing is that like FIR, Lordship.
FIR is at page?
FIR is at page number.
Page 12 is the
12
vernacular.
is the vernacular and 11 is the translated. Lordship.
May I read the Lordship vernacular? সন্মানপূৰ্বক বিনীত নিবেদন এই যে আজি ইংৰাজী 21/3/2025 তাৰিখে পুৱা প্ৰায় 8:30 বজাত মোৰ মা আৰু দেউতাই ঘৰৰ বাৰীত কাম কৰি থকা অৱস্থাত আমাৰ পৰিয়ালৰে দাদা উপৰোক্ত পদকীয়া কোনো কাৰণ নোহোৱাকৈ তাদাং চাপৰি গাঁৱৰ পৰা আহি হঠাৎ পিছফালৰ পৰা হত্যা কৰাৰ উদ্দেশ্যে কুঠাৰেৰে মূৰত 2টা ঘাপ মাৰে। ফলত মোৰ দেউতা গুৰুতৰভাৱে জখম হয় আৰু তিতাতে ঢলি পৰে। আমি ততাতৈয়াকৈ দেউতাক চিকিৎসাৰ বাবে বগীনদী আদৰ্শ হস্পিটেললৈ লৈ যাওঁ। চিকিৎসকে পৰীক্ষা কৰি লখিমপুৰ মেডিকেল কলেজ হস্পিটেললৈ প্ৰেৰণ কৰে।
যদিও লখিমপুৰ মেডিকেল কলেজ হস্পিটেলৰ পৰা উন্নত চিকিৎসাৰ বাবে অসম মেডিকেল হস্পিটেললৈ ডিব্ৰুগড় প্ৰেৰণ কৰে আৰু বৰ্তমান মোৰ দেউতা গুৰুতৰ জখমৰ বাবে ডিব্ৰুগড় আদিত্য চিকিৎসালয়ত চিকিৎসাধীন হৈ আছে বৰ্তমান মোৰ দেউতাৰ অৱস্থা সংকটজনক So this is the allegation.
He died.
Subsequently, he died.
And there is a 161 lordship I have gone through of the neighbor lordship, and they have alleged lordship. They were nearby, they have seen that he brought the axe and he assaulted with the axe lordship. So let the witnesses must be examined lordship in this regard lordship. Because the axe was also recovered from the place of occurrence. It is not a fit case to...
That recovery part is there, that's pertaining to merit. But what I have raised primarily is lordship, that violation lordship. 47 and 48 lordship. That is mandatory.
Lordship, they have given the grounds, lordship. It is not that it is not at all given the grounds. There may be some little discrepancy, but there was the ground. Axe was recovered.
He got arrested on the day of incident itself or later on?
Lordship arrested on 22nd, next day.
Next day.
Next day, immediately, Lord.
Oh. So grounds lordship has, they have furnished the ground, but whether those grounds can be construed to be ground of arrest. That is the lordship thing, lordship.
Heard Mr. Ed Hassan, the learned. Also heard MSK Begum, the learned additional PP appearing on behalf of it's an application under section so and so in connection with so and so. Scan copy of the TCR has already been received by justice. It is submitted by Mr. Hassan, the representative petitioner, got arrested in connection with this case on 22/03/2025, and since last 324 days he is in custody. Case has already been charged and charge was framed on 5/8/2025, but till that no witness could be examined by the prosecution out of 12 numbers of cited witnesses. Considering his period of long incarceration, the present accused petitioner may be released. Next, Mr. Hassan further raised the issue of non-compliance of Section 47 and 48 of BNSS. It is submitted that while issuing the notice under Section 47 and 48 BNSS, some grounds are being mentioned, but those grounds cannot be considered as the grounds of arrest. Rather, it may be the reasons of arrest. Thus, it is seen that the investigating agency had also violated the law laid down by the Honorable Apex Court in case of Pravir Broadcast, wherein it is stated that there is differences between the reasons of arrest and the grounds of arrest. If further submitted, there is no particular of the offense described in the grounds of arrest which was issued to the present petition. Accordingly, due to violation of the principle, due to violation of the Article 22(1) of Constitution of India, also entitles the accused petitioners to go on. However, the petitioner, being the permanent resident of the address locality, will the locality command there is no chance of absconding and will provide sufficient security. Next, MS Beckham, the learned additional PP submitted in this regard, that there are from the FI itself it is seen that the accused petitioner committed the offense, and that apart it is seen that there are several eyewitnesses, the neighbors who saw the accused while coming and committing while saw the accused carrying a axe on his hand and while committing the offense. The eyewitnesses are the eyewitnesses are yet to be examined by the prosecution, and hence there is probability of hampering or tampering with the witnesses if the accused petitioner is released on bail at this stage. Accordingly, MS Begum raised remain objection and submitted that his bail petition may not be considered at this stage. Later part I'll give.
Lordship. May I furnish the judgments of the Honorable Supreme Court?
Yes, you have submitted that he violated the principle laid down by the Honorable Apex Court in case of prohibited protest. That
Prohibited
was your
protest.
submission.
Yes. On one more judgment, Mihir, Lordship, that
Mihir Rajesh.
Kasi Reddy. Kasi Reddy. I am submitting, Lordship, one part, Lordship, may kindly see. One paragraph only, Lordship. Prohibited protest I am submitting, but this part, paragraph, Lordship, may kindly see for a moment. Yes, para 28. It's Kasi Reddy, Lordship. Para 28, Lordship, may kindly see a small paragraph. For the purpose of clause 1 of Article 22, it is not necessary for the authorities to furnish full details of the offense. However, the information should be sufficient to enable the arrested person to understand why he has been arrested. The grounds to be communicated to the arrested person should be somewhat similar to the charge framed by the court for the trial of a case. That is the Lordship observation.
এটা মাজত তাতে লগাই দিম এই Hassan submission or মাজত. In that context, Mr. Hassan also relied on a decision of Honorable Supreme Court passed in case of Kashi Reddy Upendra Reddy, bracket of Supra, reported white 2025-0 Supreme, bracket of SC 905, and basically relied on para 28 of this state judgment, which read as under. You put this para. Okay.
Lordship. The other judgment I am furnishing, Lordship. Obliged.
Of the back.
In item 33, charge sheet submitted.
Lordship, this matter is related to kidnapping, Lordship, under 87 of PNS, and I am since 44 days behind the bar, Lordship. 44 days. And the victim girl is already recovered, so I may be allowed to go on bail, Lordship, today.
Now, see, as case has already been charged, we're not supposed to interfere at this stage. You file an application, suppose in any case, if it is rejected, then definitely there is a way to come this court. But at this stage, we're not, that should not be ordered because charge sheet has already been submitted. The case is at its stage of trial.
After getting materials,
Lordship, this is a session tribunal case. After this, I will be not allowed to go on bail.
Here is also not in the bail. He is not interim.
No, I am not in interim, Lordship. Till
that is
commit
not
the
a question or doubt. You have to file. Take that ground that case has already been charged. These are the ground frequent. These are the grounds which generally takes while the filing of bail application. That case has been charged. That may not be further. I mean, may not be a case for further investigation. That a part guard has already been recovered. This kind of submission you can make on a trial court because as the case has already been charged, we don't want to. Okay, you are Mr.
Yehuda.
Yehuda. Heard Mr. Yehuda, the learned counsel for petition, and also heard Mr. P. Sharma, the learned additional PP, appearing on behalf of state. This was fixed for his diary, but it is submitted by Mr. Sharma that case has already been charged by its CS number.
8/26. Dated
40.
8/28.
48. 48.
No, only 8.
Oh, sorry, 08.
08.
08/2026.
Dated 25/1.
29/1.
25/1. 25.
25/1.
1.
Okay, 25/1/2026. In that context, Mr. Huda, the learned counsel for the petitioner, submitted that accused petitioner is in custody since last 48 days, and the girl is already
44 days.
44 days, and the victim girl is already recovered, and is already recovered, and hence the petitioner may be allowed to go on bail. But considering the fact that the case has already been charged, the petitioner is hereby directed to approach the learned trial court below with an appropriate application for bail, which may be considered in accordance with the above observation. The present system. Okay.
Please, your lordship. It's a regular bail application, lordship. Petitioner was arrested on 9/1/2026.
9/1
2026. As on today, lordship, 32 days behind the bar. The offense, lordship, under 105 of the BNS, culpable homicide not amounting to murder. Here, CD was called for CD, but it has been received. Lordship, may kindly see the FIR at page number 11. Vernacular version, lordship. May I read? সন্মান সহকাৰে আপোনাক জনাওঁ যে মই শ্ৰী নৱ ব্যক্তি উত্তৰ বালিজান চাহ বাগিচা কেশৰপাৰা লাইন চাবুৱা জিলা ডিব্ৰুগড় অতি পৰিতাপেৰে আপোনাক জনাব বিচাৰোঁ যে মোৰ ভাতৃ মহেশ্বৰ ব্যক্তি যোৱা ইংৰাজী 7/1/26 তাৰিখে সন্ধিয়া প্ৰায় 5 বজাত তিনিচুকীয়া জিলাৰ চতু টিংৰাই নামৰ ঠাইত বিটেক ইঞ্জিনিয়াৰ কোম্পানীৰ অধীনত বিজুলী সংযোগী পুতা কাম কৰি থকা অৱস্থাত AS-237536 নম্বৰৰ ক্ৰেন গাড়ীখন পিছুৱাই থকা অৱস্থাত কাম কৰাৰ শ্ৰমিকে বাৰম্বাৰ বাধা প্ৰদান কৰাৰ পাছতো ট্ৰেইনৰ হুকডাল ছিঙি যোৱাৰ ফলত বিজুলী খুঁটা গাত পৰি আঘাতপ্ৰাপ্ত হয়। স্থানীয় ৰাইজৰ সহযোগত চিকিৎসালয়লৈ নিয়াৰ পাছত চিকিৎসকে পৰীক্ষা কৰি মোৰ ভাতৃক মৃত বুলি ঘোষণা কৰে। So this is the incident, lordship. What happened? He was a driver of that crane vehicle, and that electric post was being constructed, lordship. And he was reversing the lordship vehicle, and that disease was working there, lordship. And despite the lordship, despite he was stopped from reversing, lordship, he continued reversing. That is the allegation. But he was driving the vehicle, and there was so much noise around, lordship. So actually, it's a lordship, definitely unfortunate, lordship. The person has died, lordship. But in my humble submission, lordship, 105, the ingredients may not come into this case, lordship, because 1061 may be, lordship, appropriate, lordship. Death due to lordship ration negligence act. Then lordship may kindly see 1061 for a moment, lordship. BNS.
You can read.
Yes. (106), lordship. Causing death by negligence. First part. Whoever causes death of any person by doing any rash or negligent act not amounting to culpable homicide shall be punished with imprisonment of either description for a term which may extend to 5 years and shall also be liable to fine. And if such act is done by a registered medical practitioner while performing a medical procedure, he shall be punished with imprisonment of either description for a term which may extend to 2 years and shall also be liable to fine. So, lordship, here, lordship, what happened? He was, lordship, driving the crane vehicle. So, lordship, while reversing, he did not know that that hook might have fallen down, because he died due to the hook of the crane fell down on him, lordship. Thereafter, he sustained injuries, lordship. Then he died, lordship. But lordship, he did not have any intention to lordship cause death. 105, lordship, that culpability has to be, lordship, established. Culpable in the intention, lordship. Here, lordship, he was in a bona fide act. The bona fide belief was discharging his lordship duty, lordship, because it was a lordship that electric pole was constructed, lordship. So, lordship, my humble submission is that 105, the ingredients may not come, lordship. And considering the fact that 32 days, lordship, he has already behind the bar, lordship. He has been thoroughly interrogated, lordship. And lordship, that crane vehicle has also already been seized, lordship. So, lordship, he may kindly be allowed to go on.
Yes, my lord, he is the driver of that train, my lord. Otherwise, statement witnesses state that he was repeatedly, my lord, asked to stop my lord, regarding reversing the train, my lord. In spite of that, my lord, reminder, he, my lord, ultimately reversed the crane hook, and ultimately, my lord, because of that electric post, my lord, fell down on the deceased person, and one of the deceased ultimately expired. Who is the statement of the witness? He is the driver of the train. Otherwise, he was warned to stop the reversing. But no.
But probably there was no such intention.
Yes.
Accidental, I
Accident.
mean, negligent act was there,
Yes.
for which a person died.
Yes.
Unfortunate incident. May not be intention.
Yes.
Our Mr. Anderson, the learned counsel, also Mr. B. Waterford, the learned additional appearing on the. This is an application under section 6. Initial CD receipt. It is submitted by Mr. Hassan, the dependent expedition, not committed in such offense as a clear. However, it is the fact that he was driving the train vehicle during the time of incident, and it was while reversing the vehicle, the incident, unfortunate incident happened. But from the contents of the FI itself, it is seen that there is no ingredients to affect section 105 PNS. Rather, it may be case in section 106, subsection 1 of PNS. And PNS, the accused petitioner is in custody since last 32 days, and thus they have sufficient opportunity to interrogate him, giving him in custody. And hence, further custody detention may not be required for the purpose of investigation. The crane, the vehicle, that is the crane, has already been seized by police, and there is sufficient progress in the investigation. However, he is ready and willing to extend his further cooperation in the investigation of this case as and when it is required. Next, Mr. Water, done it. Additional people submitted in this record. That from the statement of the FIR as well as statement made by the witness, it is seen that he did not stop the vehicle for reversing in spite of several warning given to him, and for which the incident had happened and a person. Accordingly, Mr. Porter raised objection and submitted that further custodial interrogation. Next, considering this submission made by learning counsel parties, matters available in the case diary, vis-a-vis the contents statement made in the FI and all other circumstances of this case, that custodial interrogation may not be necessary for the purpose of investigation. Where from? Cases from?
CGM তিনশো
CGM, to the satisfaction of CGM.
Plot. Amlio.
Oh.
Your Lordship. Anticipatory bail application.
Yes.
Lordship was pleased to grant me interim protection. After getting interim protection, it will appear, and perhaps her statement is with there, my lord, in the case diary. Here, initially, my lord, what had happened during the time of Eid, there were some allegations regarding my lord throwing of beef in certain particular area. In relation to that, another FIR was lodged. In that case, this petitioner was also implicated, and he was granted bail, anticipatory bail by this honorable court. In fact, the other accused were also granted. Following that incident, because this involved alleged hurting of the feelings of another community, so some altercation took place between two different groups, my lord. Because of that altercation, the second FIR was lodged. Initially, the anticipatory bail application was moved, and the lordship was pleased to reject it. Subsequently, my lord, a new development arose that all the other accused persons, my lord, couple of them were arrested, and they were first granted interim bail by the Court of Sessions in Hojai, and then their interim was made absolute. And the other co-accused persons, my lord, they were granted an absolute anticipatory bail by the Sessions Court. So when those facts were produced before your lordship was pleased to grant interim protection. Now, all the accused persons in this case are on bail. You are on regular bail, others are on anticipatory bail, and I'm also on interim bail. Perhaps custodial detention in this case may not be required, my lord.
Yes, case diary, my lord, received, my lord. You has appeared statement recorded, my lord. This is second bail application, my lord. Initially, your lordship was pleased to reject. Thereafter, my lord, whereas because all other persons were earlier allowed, thereafter your lordship. My lord, one fact, my lord, probably my learned friend may not notice, my lord. I just want to point out one thing. Your lordship may kindly come to page 42, my lord. 41. Page 41, my lord. He is my lord Abdul Wahid, the present petitioner, my lord. So because that fact has come to my notice, my lord, I am pointing. Page 43, then, my lord. Your lordship, my lord, that order was passed by the coordinate bench of this honorable court, my lord.
Oh.
Last paragraph, paragraph number 7, my lord. Though the petitioners have defaulted in appearing before the investigating officer in person to order dated so and so, this court, however, considering the offense of involved in this case as well as materials available in the case diary, they are again directed to appear before the investigating officer within 7 days from the date of this order and cooperate with the investigation. Herein, Abdul Wahid is one of the petitioners, but that is order dated 29/7. Then your lordship may kindly come to page 17, my lord. Why he has to, my lord, again approach? Probably, my lord, that fact may not, my lord, come to the notice of my learned friend, my lord. You will see page 17, my lord. 31/7. Then, my lord, the same petitioner, my lord, bail petition was rejected by your lordship.
That's a different case, my lord. The first order which my learned friend is pointing out, I have mentioned, my lord, there are two cases. First case was under the Assam Cattle Preservation Act cases regarding the throwing of beef. In that case, my lord, the order which my learned friend has pointed out, the first page 41 order, that case bail was granted.
Sorry, my lord, sorry, that is 183. Yes.
It's a different case. The first case which I pointed out, my lord, the coordinate bench had granted anticipatory bail. So in that case, he has appeared and cooperated. This is the second case which was registered because of the altercation which took place after the registration of that. This is the second. So he had to again come for seeking anticipatory bail in this case.
This is 184, my lord. That was 183.
So now at this present test, he
I appeared statement recorded. All other accused persons
are also on bail.
Yeah.
Mr. S. Nawaz, the learned counsel for the petitioner, also heard Mr. P. Potter, the learned petitioner PP, appearing on behalf of the state. This is an application under section so and so in connection with so and so. Case diary received, parents received. Submitted by Mr. Nawaz that in pursuant to order dated
16/12.
16/12/2025, the accused petitioner had appeared before the IO and extended his cooperation in the investigation of this case. He further submitted that some of the co-accused persons are regular bail and some others are in absolute anticipatory bail in connection with the present case. However, the accused petitioner is still ready and willing to extend his cooperation in further investigation of this case if his if his bail, interim bail granted on 16/12/2025 is made absolute. Next part, Mr. Potaku Learned additional PP submitted in this regard that from the that CD reveals that the accused petitioner had appeared before the IO, cooperated in the investigation of this case. More so, he also admitted that the other co-accused persons are already on bail and they are also cooperating in the investigation. Next part. Considering the submission made by learned counsel for both sides, materials in the case diary vis-a-vis the conduct of the accused petitioner, we find that a custodial interrogation may not be required for the present case, and hence the interim order dated 16/12/2025 is hereby made absolute with the same terms and conditions. The above observation may be censored.
Deeply obliged.
Hey, এইটো কি আহি আছে ভয় লাগি আছে হা মৰিব দেখোন নামাৰিব actually ভয় লাগি যায় but problem আছে মোৰ তো কয়টা সচৰাচৰ
My lord, 39 and 46 should be from the same police station, my lord.
39 and 46, my lord, same police station, my lord, regarding
39 and 46
46.
my lord.
They are the members of Bir Lasit Sena, my lord. And my lord, petitioners are in interim, my lord. And item number
39.
40, interim, my lord.
46 acha
Item number 46, my lord, the petitioner appeared, his statement is there available in the CD. But regarding item number 39, my lord, the statement of the petitioner is not available in the case.
yes what do you want to submit here
My lord, they actually, my lord, we went there. The direction was given to my lord, they appear within 7 days. They all the petitioners, my lord, they were scattered in different places for their job purpose, my lord. So all petitioners could not come in the same station in the same day.
that it cannot be
No, my lord, they came, my lord. They came, my lord. The police, my lord, say that unless they all come together, my lord, we will not record the statement, my lord. But so far, my lord, statement of the other accused in the same police case, my lord, it is recorded, my lord. I hope, my lord, whatever is submitted by the another accused, that will suffice the, my lord, purpose of the other. If it is not accept, it is not there, my lord.
that means you're violating your will
No,
or
my lord,
the order
not violating, my lord. We
Then
went there.
what are you
We
submitting
went there, but they police, my lord, they said if it not come together all, my lord, we will not taking this statement. This is the
then
problem,
go
my lord.
together
So, my lord,
go
one time,
together
my lord, one time maybe
who is
granted, my
forbidding you
my lord, one time may be granted, my lord. I will record this statement to all the accused, my lord. At least, my lord, 1 week time may be granted. They will come, my lord, and statement will be recorded, my lord. And
You're
so far,
saying
the
in case of
46 is there, my
39.
lord.
Oh, yes, 39 they have not appeared.
and 46
46
appeared,
appeared,
my lord.
statement record.
That is being recorded. But if the so far the offense is yes, my lord, it is not having any such type of extortionist took place, my lord, whatever the section is there. And moreover, lordship will see the main two accused, the Mintu Panifukon and the, my lord, Vikas Assam, that has been annexer 12 at 1 at page 12, the FIR. It is, my lord, the forwarding is specifically, my lord, stated that we are not the member of, my lord, Bill Asit Sena. We are member of the Bill Asit Sena Assam. There are two organizations. Actually, my lord, this affair has been, my lord, the result of a roar on the spike of a certain heated statement by the Bill Sena Lasit, my lord, against the outsider of the interest of these indigenous people. So on that issue, in the instruction of the, my lord, certain people, the affair was lost in some places. In that case, my lord, lordship will get the kindly see. This is, my lord, at page forwarding kindly.
At present, they have not appeared.
My lord, I will appear, my lord, but I am not on that. My lord, simply I want to show, lordship will get the page numbers. This is page annexer 2, my lord. Annexer 2.
spotting report
Spotting report. Lordship come to the next, my lord. The lordship will get the in the bottom. The Rintu Panifukon and the, my lord, Vikas Assam, they were arrested and they were released on bail also. They are the prime accused, name accused in the affair. The next page, lordship will come. Their name by showing that after that they IO said that I have been found in they have been found involved in the commission of the above offense in connection with this said case, my lord. But they are nowhere stated that the other person also involved, my lord. So, my lord, these persons, they one from Gauhati and another from Jorhat. So, my lord, it is also, my lord, it is difficult to accept how a person from Gauhati and one would come Jorhat and give a threatening to the person concerned. But there is no any means in which way they have threatened them to demanding money. Nothing is there. Only, my lord.
now see simply the question is that on your submission most probably court convenes and accordingly you were granted with the interim protection
my lord.
With a simple direction that you appeal and
I-
record your statement.
My lord,
But
I-
you're violating that
No, I am
condition.
not
Repeatedly, you're saying that you are not going to appear.
I
that
am
you
not
submit
violating, my
that, not the submission.
And I am not violating anything, my lord. I try to, my lord, convince the police that at least whenever you want somebody is come, you place the recording the statement.
In
The
item number
police said, my
46, how many petitioners are here?
It is in honor of 6 petitioner, my lord.
In item number 46?
No, we item 46 one.
Only one.
Only
He's a-
one petitioner.
one, my lord.
He already appeared.
Yes, my lord.
And after appearing, is there any requirement for his custodial detention? That's what I'm saying.
Well, otherwise,
Because considering some materials most probably
cooperating with the investigation, he is cooperating.
Plus, so far, my lord, the allegation is just, my lord, this is a very absurd allegation, whatever they have been made, my lord. No, nothing has been made that any specifically, my lord, I have made any extortion money or anything from whom I am demand. Nothing is there. Only my name has been, my lord, this entered in the affair. This is the
No,
case.
see, there are several FIRs most probably lodged
Yes,
in
anywhere,
different parts,
all over Assam.
all
any
over
FIR.
Assam.
Yes, my lord.
So
Yeah, in
I
fact,
don't
my
know
lord-
in where you are being involved. So there are many cases.
No, we are.
There are many cases,
But
many
we are,
FIRs
we
have
are,
been
we are,
listed.
we are made, but we are made
Yes, it
a
is.
name in this particular this case, my lord, not a prior to it, my lord. And moreover, my lord, we are not the member of the bill asset. We are member. There is a two organization, my lord. There is some dispute also going on. One is a bill asset Assam, and another is bill asset. We are not belong to bill asset. Whatever is mentioned in the FIR.
Just comply with the order.
No, my
first,
lord,
then
I
we'll go
will comply
here
on
for
this.
the
Since this I am
merits of
granted,
the case,
I
and
will
then it may be dismissed.
I will comply, my lord. I will comply.
Mr. P. Mohanta, the Learned Counsel, 46 to House number 46. P. Mohanta, the Learned Counsel for the petition, also heard Mr. P. Bott, the Learned additional PP appearing on behalf of the state. This is an application under section so and so in connection with so and so. Case diary received, page received. It is submitted by Mr. Mohanta that the present accused petition is innocent and he is not involved in the alleged offense. Only the name of the present petitioner has been reflected in the FIR without his any implications. However, in person to the order dated 09/01/2026, he had already appeared before the IO and cooperated in the investigation of this case. He is still ready and willing to extend his cooperation if he is granted with privilege of pre-arrest bail. Mr. Bott, Learned additional PP submitted in this regard that from the case diary, it is seen that the accused petitioner had already appeared and his statement is also recorded by the IO during investigation. He is cooperating in the IO, cooperating with his considering the interest submission made by Learned Counsel for good sense, in the case diary, which serves the conduct of the accused petitioner. I find that custodial interrogation may not be necessary for the present petitioner, and accordingly, I find it a case to extend the privilege of pre-arrest bail to the petitioner. In view of this, the interim order dated 09/01/2026 is hereby made absolute with same terms and conditions. Disposed with. Now 39 heard Mr. P. Mohan, the Learned Counsel for the petitioner, and also heard it is submitted by Mr. Portakur that in spite of the order dated 3/12/2025, the accused petitioners did not appear before the IO and their statement could not be recorded. Thus, they are not cooperating cooperating with the investigation and violated the order of this court dated 3/12/2025. Next part, Mr. Mohanto, the Learned Counsel for the petition submitted in this regard that there are altogether 6 petitioners and they resides and works in different places, and hence they could not came together before the IO for recording of their statements, and the IO also directed all the petitions to come together for recording of their statements. However, they submitted that they will appear before the IO if some time is granted by extending their prayer for interim. By extending their interim order. In view of this, all the accused petitioners are hereby directed to appear before the IO within 7 days from the date of order and to extend their cooperation in the investigation of this case. In view of this, the interim granted on 3/12/2025 is hereby extended till
on 24 to
2025. Also call for the updated list. Yes. What is the position of 41? CD received?
Yes, my lord.
Case diary received?
Case diary received.
Lordship, petitioner was granted interim bail, Your Lordship, according
He
to.
was on interim.
Yes, Lordship.
Okay.
Petitioner's name is Ihsan Ahmed, Lordship. One petitioner here.
Basically, the co-accused was interim on interim. That's why.
Yes, my lord. Initially, my lord, there are against other accused persons on the same ground. On the ground of the, my lord, initially these petitioners are involved in, my lord, match fixing, my lord. And initially, yes, my lord, BCCI also conducted and, my lord, investigation, and thereafter submitted this report. At that point of time, on the basis of that report, my lord, petitioner was initially granted protection, my lord. The coordinate bench of this honorable court initially, after granting protection in respect of the two other accused persons, already rejected the bail petition, my lord. On the same, my lord, ground, they were initially protected, my lord. Ultimately, my lord, finding materials against the accused persons. All are, my lord, FIR name accused persons, and the present petitioner is also, my lord, FIR name accused.
What do you think in that case? Let the matter be placed before the
My
that
lord,
particular bench. I
yes,
think.
yes, it would be.
He had already, I mean, dealt with the case record
Yes.
extensively. So,
Yes.
city, we are going to retain the case diary.
Yes.
So, control that's technical products. He is taking the heady bench.
No.
Otherwise, you were on interim, na?
Yes.
He is saying that particular bench he is now
sitting in division bench.
after DV, they again is sitting on singly also.
Yes.
So,
criminal bench with.
No, they took an idea. You know, interim. Bail matter, no bail.
That bench is not.
Yes. He's saying that tomorrow he is sitting in single bench also.
Yes.
Singly also.
Yes.
So maybe press tomorrow.
Yes, yes.
And equally, considering the submission made by equally Mr. Botaku, let the matter be listed before the appropriate bench. Should I mention the name also, bench or name?
My lord, it would be because earlier two bail petitions were rejected by this. So name maybe.
Appropriate bench will do it.
Appropriate bench.
Appropriate bench. Tomorrow may be listed.
And rejected
Tomorrow
because
is
of the rejection.
as the two bail petitions have already been rejected by the said bench. Tomorrow hole 10 list the matter accordingly on 10th of so and so. CDB detained till next date of listing. Tomorrow.
That number may kindly be reflected earlier rejection that petition will be
already disposed rejected like all the two bail petitions out of same FIR has already been disposed of by the coordinate bench in connection with this rejected like disposed connected in connection with AB 2998 of 2025 and AB 3028 of listed.
Tomorrow, Lordship.
Tomorrow. The interim will be
Yes,
continued.
Lordship.
Interim be continued till next year.
Okay.
$43, my lord, petitioner is in interim, CD not available.
CD not available.
Press reminder may be given.
CD not received. Issue reminder. Test when it can be.
My lord. On my
Last
lord.
part of
On
it,
25th.
because there are many matters.
Yes, on
Pardon?
26 to
26. 26 to 2020. Interim be continued till next day.
Obliged, my lord.
Please, your lordship. In this case, the petitioner was granted interim protection. None of the grounds was, if your lordship will kindly turn to page 27. There's a which had taken place over a land dispute, my lord, and two of the victims had died. And this petitioner had also sustained injury. In lordship can see he was bedridden.
27.
Page 27, my lord. The rods were inserted on his leg and he was bedridden, my lord. So when interim was granted, my lord, on 8/1/2026, my lord, there was no direction to appear before the IO because he was bedridden, my lord, and not in a position to appear.
On 8/1.
8/1, when interim was granted, that at that point of time, this person was bedridden. So he was not in a position to go to the police station to record his statement. So his statement would not be there. Now, my lord, his condition has improved slightly. So if your lordship passes an order directing him to appear, he can appear and your lordship can have the updated case diary.
So direction was not there.
Not there. But because of this condition, because he was bedridden, my lord. Unable to move, my lord. Now he is on crutches, my lord. So at this stage, at least somebody can take him to the police station so his statement can be recorded. The IO came to his house, but seeing his condition, did not record his statement. Only took the bail order.
My lord, here that is the matter already submitted by my colleague, my lord. Here we have received the case there, but regarding his interim, whether he has appeared or statement is not available in the case.
Interim order is also not available.
Not.
Why didn't you produce
The
the
interim order
order?
was given to the IO. Copy of the certified copy of the interim order was given to the IO because IO came to his house. Certified copy was there, but because his condition was bad, my lord, his statement was not recorded. Now, if I
have not found the my lord interim order.
Perhaps because his statement is not recorded, maybe that is why they have not annexed it to the case diary, my lord. But I have instructions that when the IO came to his house along with the officer in charge to arrest him, the bail order was given, and then the IO said that we'll come later on, let him, his condition is bad. Now, since he is slightly improved, my lord, at least his family members can take him to the police station.
Forty-four. Heard Mr. S. Nawaz and the petitioner. Heard Mr. B. Sharma. The learned additional PP apprehending behalf of state respondent. This is an application for non-liability. CD receipt with bills receipt. However, it is submitted by Mr. Nawaz that while granting the interim order, dated interim bail dated 08/01/2026, the petitioner was not in a condition to move, and he was completely bedridden condition, which is shown in the photographs which has been annexed along with the petition. For said reason, there was no such direction for this petitioner to appear before the IO. IO only the direction was given to cooperate in the investigation. As the condition of the petitioner is slightly improved and he is now able to walk with the help of brush, he can appear and the police may record his statement. Mr. Nawaz further submitted that the investigating officer along with the officer in charge of the concerned police station also visited to his place for arrest of the present petition, but considering his condition and also as the order of interim protection was provided to the police officer, they did not record his statement, and they recorded his statement on that day. But now the petitioner is ready and willing to appear before the IO to record his statement. Next para, Mr. Sharma, the learned additional PP, submitted in this regard that the statement of not only the statement of the statement of the accused, neither the statement of the accused nor the order of the interim clearance bail is available in the case diary. In view of this, the petitioner is hereby directed to appear before the IO within 7 days from the date of order and to cooperate in the investigation of this case. Full stop. In view of this, the interim order dated 08/01/2026 is hereby extended till next date of the matter accordingly. Yes, when it
My lord, 27, my lord, 27 February.
27th of February, and also call for the updated case diary along with the
Statement of
statement of the accused petitioner.
Deep look. I
May,
receipt?
CD receipt. Oh,
may I please your lordship?
Yes.
My lord, 69 BNS had been, my lord, registered. My lord, may be pleased to find the FIR is at page 17. My lord, the both were adult. My lord had a very, my lord, cordial relationship and with consent, my lord. Now the my lord informant has turned around and lost this FIR. My lord. Pursuant to a, my lord, the interim protection provided by my lordships, my lord, I have already appeared before the IO also.
Yes. You have already appeared.
I have already appeared, my lord. My statement had also been recorded, my lord. That's the instruction I have received, my lord. So, my lord, the both were in a very, my lord, cordial relation was there, my lord. But due to some misunderstanding and there is a pressurization, my lord, from the informant that the marriage should be solemnized, my lord. So, my lord, as I have declined that at this stage it is difficult. So, my lord, that's why all these allegations are coming up, my lord.
my lord, I have received the case there, my lord. Proceeding kindly page 183 statement, my lord. Where she has categorically integrated the present petitioner, my lord. And regarding the interim, my lord, he has appeared and statement also recorded.
Custodial interrogation, my lord, may not require, my lord. If anything is there, my lord, I will cooperate with the investigation.
Allegations are also serious in nature, my lord. 183 statement.
My lord, my lordship knows, my lord, that the recently the Honorable Apex Court is also very clear, my lord, regarding this type of allegations after the, my lord, consensual. Now turn around, my lord, and the leveling this type of allegations, my lord, is not tenable. Now, my lord, only thing is that, my lord, as I have denied the, my lord, at this moment it is not possible, but in future, as my lord, the informant is also lesser in age also, my lord. That's the issue. And he's a student, my lord, studying, and his examination is coming also, my lord. I think some degree first year or second one is like that, my lord. So, my lord, as I have appeared, my lord, and cooperating with the investigation, custodial interrogation.
Heard Mr. Air the learned counsel for the petitioner. And also heard Mr. B. Sharma, the learned PP, appearing on behalf of the state of Congo. This is an application on sections Wednesday in connection with Swens and CDs. It is submitted by Mr. Bhuyan that It is a fact that both the accused petitioner and the victim had love affairs, and there was physical relationship between. There was also physical relationship between them, but those were purely consensual. But as when the present accused petitioner refused to marry the victim because of his age and comma, the petitioner, sorry, the victim had lodged the FIR with some false and concocted allegation. However, after obtaining the order of interim pre-arrest bail, he already appeared before the IO, extended his cooperation in the investigation of this case, and considering the nature of the offense, his custodial interrogation may not be necessary for the purpose of investigation. However, he is still ready and willing to extend his cooperation in further investigation of this case if he is granted with the privilege of pre-arrest. Next para, Mr. Sharma, the learned additional PP submitted in this regard that the accused petitioner appeared before the IO and his statement is also recorded. But from the materials available in the case diary, especially the statement of the victim recorded under section 183 BNSS, it is seen that she implicated the accused petitioner and implicated the accused petitioner, directly showing his involvement in the arrest. Mr. Sharma accordingly is objection in granting bail to the present petitioner at this stage. Next para, hearing the submission made by learned counsel, considering the materials in the case diary, also considering the fact that the petitioner had already extended his cooperation, find that custodial interrogation may not be required for the purpose of investigation. In view of this, the order of interim pre-arrest bail granted to the present accused petitioner dated 19/01/2026 is hereby made absolute, same terms and conditions. The above observation.
Highly obliged, madam.
What
May I
where we
please,
have
Lordship?
received the case.
May I please, Lordship, Lordship, kindly adjourn the matter for the day, Lordship. Learned counsel S.S. Zaman, he suddenly fall ill, so Lordship, he left the court.
Jaman,
Yes, Lordship.
he is where he is?
He suddenly fall ill, so.
Ill.
Yes, Lordship.
Achha.
Lordship, some other person filed a NSFD bail 1721. It's fixed at 22 February, Lordship. Check with this matter.
Connected very.
Yes, Lordship.
22nd of February.
Yes, 20.
But it is too long, man. Today is only
But we have to retain the case diary. Case diary is available with us. Since 22 till 22, retain may not be possible. We understand what it's saying.
22, Lordship. 22 this month, Lordship.
That is why today is 9.
That's what I'm saying.
Yes, sir.
20.
20, Lordship.
20 also may not be possible. If it is possible, Sharma, you can retain it.
My lord, here and matter and other matters are my lord 20.
20.
20. You are Mr.
N. Islam.
N. Islam. Mr. N. Islam, heard Mr. N. Islam appearing on behalf of Mr. S.H. Jaman, paid for an adjournment, stating that suddenly the NK's counsel fell ill. CD received. Let the matter be listed on 20/0/22. CD be retained till next day. Are you on interim?
No, Lordship.
No.
And I say whether it is required for along with other.
Interim was there. No interim.
No. Who will retain the city, man? Who will retain the city? Retain the city, man.
Retain the CD. No. Admission, it will be You're ready for hearing this case?
No, Lordship, what has happened?
No, we are not. I'm not going to hear the matter. That's what I'm saying.
Yes, yes. We are also not praying for any hearing. What has happened? We had taken steps on 16.8. The respondent number 2 has refused it. It is clear
there.
from the office note.
Okay, that's
So we will take fresh steps. 16.8/2020.
one is state. State is one.
Yes, state is one.
We'll take fresh steps.
But now see, there is office note on nine. You're saying you are on which office note? 19.8.
First 16.8.
16.8.
First office note. Wait, sir.
16.8, not 16.8. It is 19.8.
Sorry.
19.8. But now if you see, one part is refused. Answer of notice in respect of so and so has been received back. Postal remark. Flag X to put a say, flag X or Y to put a say, na. Flag X. This is really এইটো ওলাইছে আৰু এটা অলপ white. Husband. This up to only husband. Your petitioner, the respondent number 2 is some Farhana Laskar.
Yes, the informant.
Was delivered. And
Tomorrow is the
see, these are one so directly refused.
Yes.
And number 2, this service report also, it seems that the husband received the notice.
Yes. Then my
So it can be proceeded.
Yes.
Why you take fresh steps?
Yes.
Because refusal can be deemed to be served in fact.
Yes, for the them to be served.
Therefore, Lordship, interim order may be continued and Lordship may fix it.
It was an interim was there.
Yes.
It is basically what? It is a case of quashing.
Yes, case of quashing. In the search sheet, there is no allegation. Every point was negated in the search sheet. However, cognizance have been taken. We have challenged the search cognizance.
Order of cognizance.
Cognizance. Dated 4/5.
Mr. P.P. Bora, the learned counsel for the Mr. P. The learned additional PP appearing on the state response. From the office note dated 19/8/2024, it is seen that the answer of notice returned back with a report as refused to receive, which is placed as flag X, and in the same time it is also seen that the husband of the respondent number 2 had already received the notice, and the report is also kept in the record as flag. Thus, from the report, thus from the note of the office note, thus from the office note as well as the report from the process server and the answer of notice. On the answer of notice, it is seen that the respondent number 2 had refused to receive the notice, as well as the notice through process server has already been received by the husband of the. Thus, it is seen that the notice is served on. Thus, it can be deemed that notice is served on the respondent number. However, no one has represented the respondent number. Let the matter be accordingly listed for admission hearing.
The month of March, 11th of 12th of March.
12th of March. 12th of March.
Interim order passed.
Oh, sorry, interim order We continue to the next step.
Please, Lordship. But in this case, several times we have taken steps earlier. But on the last occasion, it was written that you will take again first step and the alert PP was asked to receive instruction. Our instruction is this, my lord. Respondent number 2 has got notice, but he is not coming. So he was asked to receive instruction. And I am behind the bar since last 1 year, more than 9 months. 1 year, 9 months. And fixed
So
period
receive
5 years.
instruction
back.
Yes,
from him.
short date may be fixed. I'll get the instruction.
You
My
were
lord,
asked to
may I
take instruction.
pray?
Yes, ma'am.
May I pray, my lord, because in this manner so many dates are going. So one amicus curiae may kindly be appointed. My lord. Otherwise, I am in jail. The girl has said that he has done nothing with me. The amicus curiae may be appointed and
I will get the instruction any short
Take
date.
instruction.
the instruction you are receiving since 11/9/24.
11/9.
First steps we have taken on 13/9/24.
No, he will take instructions only. You are not going to. You are not asking to take fresh steps. Only the instruction he will take. Informant has implemented as a
That
respondent.
was also earlier asked.
You were asked.
He was asked to receive instruction. That's why, my lord. He was asked. Kindly see the
Yes,
last.
that most probably due to some pressure he could not take instruction. But where is the? This is the first order. মানে বুজি পোৱা নাই আগৰ record বিলাক ক'ত আছে হেৰি হেৰি এইটো কি এইটো ফাৰ্ষ্ট অৰ্ডাৰ নে কি অৰ্ডাৰ এইটো ৰিচিভ ইনষ্ট্ৰাকচন টু ফাৰ্ষ্ট অৰ্ডাৰ
I have later on I have filed.
1911 order, kindly see. 1911.
মেইন কেছ what is the I for? I is for?
I have for bail.
আমি এখন ঘুরি পাইছি নাকি in the main case also it is not I mean
Yes.
Amicus curiae, my lord, I think both the purpose would serve.
This time I
I
will get the instruction.
I to Mr. M.A. Mahmood, the learned counsel for the petition. Applicant and also heard Mr. No, appellant applicant. And also heard Mr. B. Portakur and an additional PP. It is submitted by Mr. Portakur that 1 week time may be granted to take instructions in regards to service of notice on the respondent number 2. Prayer aloud. Want here any fixed date here?
My lord,
Short date.
on 12 to. Oh,
12 to.
no, 12. Sorry, my lord, on 19 to.
19 to.
A little short date, my lord.
List on 19 to. None appears on for the appellant. Heard Mr. P. Waterford, the learned counsel for the response. Please estimate record after 2 weeks as an appeal.
This is a jail appeal. I'm appearing as an amicus.
Appearing for both.
My lord, process has been wrongly.
against your professional ethics, you appear.
Tomorrow also, my lord, in another case where I'm appearing as amicus, my name has been reflected both for the petitioner as well as on the other side. Here, my lord, records have come, but there is an office note, my lord, 4/2/2026. Service is awaited in respect of respondent number 2.
It's again a POXO.
POXO, my lord, 7 years imprisonment. Well, records have come and service will take some time. So if your lordship may direct the registry to prepare a paper book that becomes convenient for everybody, my lord. Because anyway, it will take time for service, man.
Record we have already received.
Records have been received. I don't have anything, but only the first order of this honorable. I only have the first order of this honorable court. Registry has not given me anything.
Oh, why?
Perhaps because, my lord, the records have now come. Earlier I was appointed.
Okay, we'll provide. Heard Mr. S. Kamal, still on it, amicus, duty appearing for the appellant, and also heard Mr. P. Bortaku, still on it, appearing on behalf of state. From the office note, it is dated 4/02/2026, reveals that service is still awaited for the respondent number. It was also gone through your office.
Yes,
note,
yes.
In view of this, the additional P is hereby asked to take instructions in regards to service of notice on respondent number. Further, considering this submission made by learned amicus, the registry is hereby directed to prepare the paper and to provide the copy to the learned amicus who is appearing for the appellant. After 2 weeks, it will take some time after.
Yes.
Let the 3 weeks be.
3 weeks.
Let the matter be listed 3 weeks as when I did raised. Roja month, the Ramzan is already started.
No, man, it will start on 19th of February, man.
Oh, 19th of
19th of
February.
February.